Yes, Your Honor.
Thank you very
This
much.
Thank you. This application hearing is in the matter of case number CFI 092-2021 before Justice Sir Jeremy Cooke. The claimants are represented by Towers and Hamlin's LLP lead counsel is Mr. Harris Bohr. The defendants are represented by BSA Ahmed bin Hazim and Associates LLP. Lead counsel is Mr. William Pasifka. Apologies.
Yes. Very good.
Good morning, my lord. There's a number of applications before you today, and we've tried to come to an agreement in terms of the order of events, and there's a slight disagreement there. But what you have in front of you is a contempt application. Then there's an application for an unless order in relation to this set-aside application of my learned friend, and then there is the set-aside application itself. And in terms of order, what we say should happen, with your permission, is that we should start with the contempt application and followed by our unless order. And then only if we fail on the unless order application should we get to the set-aside application. My learned friend wants his set-aside application heard first, followed by contempt. In his email to me, you didn't mention the unless order, so I don't know where he sits in relation to that, but that's the order he wants.
Yes, my lord. Just within Pacifica for the defendants, what I would say is that as of now, the court has heard on 2 occasions from Mr. Bohr. It first heard from Mr. Bohr on the 9th of November for approximately 1 hour and 20 minutes. It then heard from him a second time on the 25th of November for approximately 35 minutes. As of right now, the court has not heard from my clients. So in those circumstances, I would submit that I should be allowed to open my application first. I'd put it no further than that.
Right. Well, self-evidently, I've had a look at the papers and come to a provisional view. But the first question, I think I need to hear and to answer is why I should listen to you at all, Mr. Krasivka, in circumstances where your clients have completely ignored and flouted the court's order. So that's the first question. And if I should hear from you, what I should hear from you on.
Well, our submission is that the order was improperly made ab initio. And what all the authorities point to is that even when a party is in contempt of court, and by the way, I would say there's no finding of contempt against us as of yet, but even when we are in contempt of court, a court should hear from a party that is seeking to set aside the underlying order. There is Court of Appeal authority on that point, Motorola and Uzan. I'm happy to open that to the court, and they're the principles in which I'm relying.
Well,
perhaps could I have
there are a number of different points which arise. First of all, in the context of an appeal from an order is one thing. Where a court has made an order and there has been no attempt to comply with it, you say have not been found in contempt. Well, that's true, of course. But there's no doubt at all that you failed to make the disclosure that was required by the order. Failed to... Sorry?
Apologies. Well, it seems to be Mr. Bohr's contention that in order to argue that the court should not have made the order in the first place...
Wait a minute. Wait a minute,
apologies,
Mr. Prosecco. The problem is this, from your perspective, which I invite you to address me on. The court has made orders. I understand you say the court has no power to make those orders. And that may be a different argument from saying the court should not have made the orders. I understand that point. But the court having made the orders, you come before the court today with not the slightest apology, with no attempt at all to comply with any of the orders, and having ignored them for a year. Now, if you want to address me on what Lord Justice Potter said, that's all well and good. But on the face of it, we're in a different situation from an order that has been made and is now being appealed, because you have failed to come back to the court to argue the point for 9 months, nearly a year. So, so that's the first question that I want you to address.
Well, I think as a matter of procedural fairness, I think the claimant's position is that in order to argue that the court has no jurisdiction or no power to make the orders that it made, we would firstly have to pay $250,000, and then we would also have to submit to the court's jurisdiction. I mean, so to an extent, by complying with the order, we are to an extent undermining our own argument.
Well, there's plenty of authority, isn't there, that you can comply with a moreover injunction without submitting to the court's jurisdiction.
Well, I think I don't think as a matter of procedural fairness, we should be forced to pay $250,000 simply for the privilege of having to argue that the court didn't have the jurisdiction to make the order that it made in the first place. And likewise, I don't believe we should have to effectively submit to the court's jurisdiction. I mean, I would say that it's
not talking about effectively submitting to the court's jurisdiction.
Well, I can put it no further than that. Now, my client's position is set out in his affidavit. There are something like 25 separate proceedings have been launched against us by the claimant or entities related to the claimant in the past several years. They are all over the world. We have absolutely no connection whatsoever to the DIFC. And our problem with the DIFC order is essentially that the claimants have taken the DIFC order and effectively transformed a 4-page Kuwaiti statement of claim, given that the imprimatur of the DIFC courts, and gone around the world attempting to enforce it. Now, I say to make our arguments, we should not have to pay huge sums of money and then give very, very invasive disclosure orders. I would also say that the judgment of Lord Potter in Motorola and Uzan, I believe, is on point in this case. I fully accept that it was an appeal, but I think the underlying principle in Lord Potter's judgment is that a party, even though it may well be in contempt of court, a court should still hear that party as to the validity of the underlying orders that put it in contempt in the first place. So I think there's an overlying principle. I don't believe a court can perpetually shut a party out. I mean, I don't know what Mr. Boer's position is, but are we to be perpetually shut out of making any arguments whatsoever? And how does that fit in with fair procedures? We simply want the right to be heard.
The ordinary position, Mr. Pacifico, is this, that in order to be heard by the court, you purge your contempt. You comply with the court order. Now, it would be perfectly possible for you to have complied with the court order without submitting to the jurisdiction, wouldn't it?
I would disagree with the first premise of the statement that you made. I don't believe that is the normal course, that to be heard, you need to purge your contempt. And my authority for that is the judgment of Lord Potter and Motorola and Uzan. And it's very important. It's very important. Yeah.
I mean, I have to tell you, Mr. Pacifica, that my experience in over 50 years is that that's exactly what the ordinary position is with contempt. Now, of course, it's also true that most of those cases don't raise the question whether the court has power to make the order in question, which is why at the outset I said I perceive a difference between an argument that's based simply on the court has no power to do what it did, and the court making the order that it did. Because if a court has the power to make an order and makes an order, it should in every circumstances be obeyed, particularly in circumstances where the alleged contemnor has had the opportunity to come back and argue the toss and has failed to take it. Anyway, let's look at Motorola.
Yes, so Motorola and Uzan, I think the relevant section is at page Q536.
Right, bear with me.
And it's important to emphasize this point, and with the facts in Motorola and Uzan, the defendants were found in contempt. The 4 defendants were then sentenced to terms of imprisonment.
Yes. And
the 4 defendants then appealed not only the sentences in prison, but they also appealed the underlying order. And really important is that the 4 defendants on appeal did not purge their contempt. And likewise, likewise, the four defendants showed no willingness whatsoever to comply with an order made by the Court of Appeal if it wasn't in their favour. So,
yes. As it wasn't in the end, was it?
No, well, it wasn't. I think for two of the defendants it was. Two it wasn't.
Is that right?
But, yes. So there are four defendants in Motorola and Uzan, and two succeeded in having the underlying injunction vacated, and two did not succeed. But I think that the key point here is that those defendants were allowed to be heard not only when they were in contempt, not only when they had been sentenced to terms of imprisonment, but also when they showed no willingness whatsoever to comply with the terms of the order of the Court of Appeal.
Yeah. Take me to the relevant paragraphs you want me to look at.
So at paragraph 50, which is then at the bottom of page Q536, I will read it aloud if that's convenient. Although the more modern authority has made clear that the discretion of the court is free from the constraints of such a categorized approach, the proposition that a court will hear a person in contempt when the purpose of his application is to appeal against the order disobedience to which has put him in contempt has the merit not only of good sense, it seems to us necessary to satisfy the considerations of fairness. So I would submit that Motorola and Uzan is precisely on point in this case.
Well, what do you say about the difference between an appeal on the one hand from an order that has been made and where we are today?
Well, again, as the court is aware, Motorola and Uzan is not binding. I'm relying on binding on a DIFC court. I'm simply relying on it as persuasive authority. And it's what is the principle at stake? And the principle is that a party should always be heard. I would argue that is, I mean, I suppose at the base, at the very root of the common law, and they should be heard even if that party shows no willingness whatsoever to abide by the terms of an order.
Is there more you want to say on that point, Mr. Pacifico?
Well, I would just also refer the court to page Q524. And this is just a head note to Motorola and Uzan. And just to read it aloud, held, quote unquote.
524, did you say?
Yeah, Q524.
Yeah, thank you.
Held, the circumstances would be rare indeed where it would be right for a court to exercise its discretion not to hear a person in contempt, where the purpose of his application was to appeal against the order disobedience to which had put him in contempt. That it would be neither logical nor appropriate to exercise that discretion not to hear argument directed to the reversal of the freezing order to which the orders for cross-examination were ancillary, and that in all the circumstances the defendants should be heard upon all of their appeals and applications as well that were before the court. So I simply don't believe we can be completely shut out from the court.
Yes.
And there's also a further section just to refer the court to, which is at Q535, and it's at paragraph 45 of the judgment quote, and it's the title of the section the section is titled "Should the defendant's appeals/applications be heard?" So again, the Court of Appeal is not making a distinction between an appeal and an application. And I would strongly invite the court to read that section. And it says clearly in paragraph 45, quote unquote, they have no intention of obeying those orders if they lose their appeal. So even if the Court of Appeal was very much aware that effectively if an unfavorable finding was made, it wouldn't be obeyed. But the Court of Appeal still went on to hear the appeals, and the Court of Appeal discharged the injunctions against 2 of the 4 defendants. So I think we fall precisely in I suppose, the territory identified by the Court of Appeal in Motorola and Uzan.
I'm just reading 47 onwards. Do you accept that the test set out by Lord Bingham at paragraph 48 is the right test to apply?
I think I don't see anything wrong with. I think that I do, but I would say that what Lord Potter is doing, he's summarising all of the relevant authorities, and the summary of all the relevant authorities then appears at paragraph 50. So I would say the Lord Potter's summary at paragraph 50 is the correct test to be applied. Though I think obviously the judgment of Lord Bingham is obviously one aspect of that.
Well, on the face of it, the second sentence of that paragraph would appear to bring in just at a level of generality, at least, would appear to be the right principle to adopt.
But Lord Potter goes on to say specifically that, quote unquote, the proposition that the court will hear a person in contempt when the purpose of his application is to appeal against the order of abeyance. So I think that has to be the key test. I mean, I think if the court's view is that we should have to pay $250,000 up front simply to be heard, and simply to be heard on whether the court had power to do what it did, I just don't think that is fair.
What you think is neither here nor there. It's your submission that matters.
Apologies, Judge. It is my submission, so I accept that. That's a fair point.
I'm sorry. It's one of my bête noirs, as counsel who say I think that.
Yes.
Anyway, there we are. Yes. Well, I've got your point. I confessed to preferring the way Lord Justice Bingham put it, which gives a greater discretion to the court. But at the end of the day, I think everybody accepts what has to be done is what's fair in all the circumstances. But when a party shows contempt for the court, and the reality is, Mr. Pasifka, that rather like the Uzan case, your clients are showing no willingness to pay any attention to anything this court says. There's been no suggestion that were I to find against you, there'll be compliance in the future. And in a sense, whilst I take your point about payment of money, perhaps, it's the disclosure orders that are the key question here. Anyway, let me hear from Mr. Bohr, unless there's anything further you want to say at this stage.
No, I think Lord Potter's statement at paragraph 50 is really the key point that I want to make.
Yes, well, you've made that. Thank you. Yes,
thank you, Bohr. I think my learned friend has started from the wrong end of the telescope slightly. If there's some documents that was sent to the court separately after the skeleton argument, I don't know whether you have those. There's a section 2 from G on injunctions.
Where will I find that?
It was sent by email.
Is that in bundle R? Is that in the new bundle R?
It wasn't included for some reason in the bundle, but it came 1756 on the 21st November from Daniel Smith to the court registry.
I don't think I have that.
Okay, well, I mean, maybe the best thing to do is I'll read it because it's just a few sentences, but I believe it's something that the court's already picked up already. But this is from section 2 of G on injunctions, and it's the first paragraph. It says, an injunction takes effect at the moment it is pronounced, unless the court orders that it is to take effect from a later date. It continues in effect unless and until it is set aside. Breach of the order is a contempt, even if subsequently it is set aside. And then that same sentiment is expressed at section 5 of G, which says no one can justify contempt on the grounds that the order should never have been made or was irregular. If an order has been made, it must be obeyed until it is set aside. And then it goes on to say whether the original order should have been made may be irrelevant to an appeal challenging a committal order made on breach of the order. So the starting point is that the order was made and should be obeyed. Now, my learned friend said it was unfair for him to have to even pay the 250,000. But of course, it was always open to his clients to come back at the return date and to argue for the discharge of the order at that point. Or indeed, at any point subsequently, we served further evidence. As matters went along, we updated the court quite properly. At no point did the defendants come before the court until we made an application for contempt. And we say that is far too late. And that is very different, of course, to the situation in the Uzan case. That was a situation where the respondents challenged the order early doors, and that was not successful. And then they appealed.
I think.
Sorry?
Was it before me?
Was it before you in the Uzan case?
Yes.
Oh, it may have been. I don't know.
I certainly had some. I certainly had some dealings with it. I think the application to discharge was made to me. I can't quite remember, but
right. Well, it's a small world. Maybe it was. I don't know. But either it's a very different case when if for example my learned friend's client had come before the court and sought to challenge the order and then appealed the order, then you would be into the realms of paragraphs 48 and 49 and applying the test of Lord Bingham, etc. But we're not in that realm. In fact, what's happened is the other side, the defendants, did nothing at all. And as you say, as observed, my lord, they made no apology. They've made no statement that they will comply if the court finds against them. They haven't even, in fact, put in a defense to the contempt application. They've merely put a set-aside application, and all the evidence is said to go to that application. So they want the indulgence of the court, and yet they just willing to turn a blind eye completely to the contempt and the injunction. So that's very different. You looked at paragraphs 48 and 49. Another important paragraph, I think, is 150, which is at page 559. So it's Q559.
After we've gone there, can you show me any subsequent reference to this principle in either the Court of Appeal or elsewhere, or even in G, I suppose?
Yes, I will.
Harris, can I just interrupt? I've got the bundle reference for G is at R39 to 65 is section 2, and R66 is section 5. Just so you've got them.
Thank you very much.
Sorry to interrupt.
Oh, I may have an earlier bundle of Q. So if Mr. Schauder could, I may refer to other authorities if you could just let us know as well where that is.
Well, I raised that with you, Mr. Board, that a new section R has been added to the electronic bundle.
Okay.
So it's probably all in there. But anyway, take me to what you want to take me to.
There's 150.
Did you say 150?
Yes. Do you have that paragraph?
Yes.
So actually, you may want to scroll up. So Mr. Strauss accepts, I'm looking at 149, accepts that as a matter of domestic law, a person against whom an order is made must obey it until it is discharged. But he says that this principle should not apply to someone over whom the court has no personal jurisdiction at common law, and where the court has found that jurisdiction should not have been assumed. And then 150, the court says it's not necessary to consider submission in any detail because there's a simple answer to it. And that is that section 25 gives the High Court jurisdiction to grant interim relief in aid of substantive proceedings of any kind and wherever taking place. And there's a reference to CPR. And then it goes on to say there is no requirement that the claim should ultimately succeed. and the defendants have not demonstrated that on the information before more big J, permission to serve the claim form on them out of the jurisdiction should have been refused. The initial court did have and still has jurisdiction over the defendants. It was, and is a separate question as to whether it was an expedient to grant interim relief against them. We have disagreed with the judge below by holding, etc. So the point is, and this is the same principle again, and this is the point where, in fact, there's an expediency issue. But the court says once the court's got jurisdiction, that's it. The order's binding. Now, my learned friend wants to say the court doesn't have jurisdiction. Yeah. But his big problem with that is it's the same issue that I mentioned before. He had an opportunity, and his clients had an opportunity, at any rate, to come before the court as soon as the order was made at the return date, or indeed they could have asked for more time, or at any point where we serve further evidence, but they didn't do so. This court has jurisdiction. My learned friend's skeleton argument refers to the case of Jones, which your lordship will be very familiar with, of course, where the court has set out why it has jurisdiction in cases like this. I mean, that's the law. But even if there was some doubt about that, my learned friend's clients decided not to challenge jurisdiction. And so we're not
Sorry,
even...
just say acknowledgement of service specifically challenges jurisdiction, just to point it out.
Yeah, no, we've got that.
Now, in terms of other cases, there is a case, Paratus, which should be in bundle R in that case. I don't have the exact reference because I don't have it open in front of me.
What's it called?
It's called Paratus AMC.
Yes, it's R31. Have you got an electronic bundle in front of you, either of you?
I have the PDF of the case.
Right, well, it's R31. Mr. Justice Sales, as he then was.
Yes. If you turn to paragraph 5 of that case.
Yes.
This was an order to pay money into court, and what Mr. Justice Sales says is since Paratus was subject to an order of the court and had not made any application at that time to vary the order that had been made against them, let alone made an application which had been granted, Paratus had no proper justification for failing to pay into court the full sum that it was ordered to pay. The appropriate course for it should have been either to apply for a variation of his order in good time before it came into effect, or having failed to do that, to pay the sum it had been ordered to pay into court, and then to apply back to the court for a variation of his order and a payment out of part of that sum back to it. It did neither of these things. Instead, it took upon itself, in breach of the order and in contempt of court, to pay the lesser sum. And so there's a similar idea again. I mean, applying this to our case, my learned friends could have approached the court in good time. They could have paid the money and then claimed that they shouldn't have paid it and sought to have it sought the order to have the order set aside and return of the money. But they did nothing. They didn't pay a penny, never mind a lesser sum, as in the Paratus case. So moving to a different authority, there's an authority called Mercandani, which is also in the R bundle.
Merchandani, I think.
Merchandani, sorry.
R16.
I'm grateful. And if you go to paragraph 36 onwards.
Sorry, bear with me. It always takes time to catch up when you scroll down.
Yeah.
36, yeah, I've got it.
Yeah. So you have a sense of what this case was about from that paragraph. That's similar. There was an inter-parties hearing and one party didn't apply at all. And then the court refers to Court of Appeal authority in Channel Limited versus Woolworth. The defendants are seeking a rehearing on evidence, which much of it, which so far as one can tell, they could have adduced on the earlier occasion if they had sought an adequate adjournment, which they would probably have obtained. Even in interlocutory matters, a party cannot fight over, a battle which has already been fought unless there has been some significant change of circumstances, or the party has become aware of facts which he could not reasonably have known or found out in time for the first encounter. the fact that he capitulated the first category cannot improve a party's position. And then para 38 refers to another case where Mr. Justice Popplewell said, the principle is well established and often applied in relation to contested interlocutory hearings. It is that if a point is open to a party on an interlocutory application and is not pursued, then the applicant cannot take the point at a subsequent interlocutory hearing in relation to the same or similar relief, absent a significant and material change of circumstances, or is becoming aware of facts which he did not know and could not reasonably have discovered at the time of the first hearing. And it's based on the principle that a party must bring forward in argument all points reasonably available to him at the first opportunity, and that to allow him to take them serially in subsequent applications would permit abuse and obstruct the efficiency of the judicial process by undermining the necessary finality of unappealed interlocutory decisions. And that's exactly the position we're at. My learned friend could, of course, have come and challenged jurisdiction to make the order at the return date, but did not do so. And indeed, it is an abuse of process to wait almost a year. And then in the face of contempt proceedings, instead of dealing with those proceedings, apologizing, trying to purge the contempt as far as possible, because their client didn't perform and didn't comply at all with the order, instead of doing that, they then launch an application to set aside the order on grounds which are inherently weak because of the Jones case, but also far, far too late, and in a situation where, in fact, they're in flagrant breach of the order, and we would say contempt. And so we say that the court, exercising its discretion and having regard to these cases, should not allow my learned friend to rerun all the arguments that could have been made at the return date, and certainly not to pursue the set-aside application. And we should really be dealing with the contempt application, which is going to be a short one, it sounds like, having heard what my learned friend says, and then deal with how his application should be dealt with with respect to an less order. Unless you have any further questions for me, Randall.
No, Mr. Pacifica.
Yes, Judge. So just a few procedural points. Firstly, I'd like to go to the precise terms of the order dated the 30th of November 2021, and I'd invite the court to go to page G17.
Yes.
And this is paragraph 13. So the very first thing the order states, quote unquote, is that any party can apply at any time to vary the order, and provided that they comply with the service of evidence requirements contained in paragraph 13. So I think there's no dispute whatsoever that we have complied with paragraph 13. So that is the basis of our application today. Now, just substantively, our case is the underlying Kuwaiti proceedings on which the injunction was based have been dismissed. So if the court is then saying that the injunction must stand in perpetuity, despite the fact that the underlying proceedings have been dismissed, I would submit that is manifestly unfair. And likewise, the Kuwaiti proceedings make a claim for reflective loss. This is a claim which is not possible to make within the DIFC. And then finally, there's the issue of not being subject to the DIFC's personal jurisdiction, not falling within any of the gateways set out in Article 5. And if the court is to deny us the opportunity to even make that application, I would submit that that would be firmly against fair procedures. And also, the final point about Motorola and Uzan, permission by the Court of Appeal was given to appeal to the UK Supreme Court, and the UK Supreme Court refused to accept the appeal. But again, I just would say that that decision, Motorola and Uzan, stands, and I would invite the court to be bound by it.
Yes. Can you just remind me what the reference was? I've now moved away from it and failed to note where it was in the bundle.
Yes.
Thank you.
The bundle reference or the judgment reference?
The bundle reference. It's just so I have it on my screen.
Yep.
We were looking at not long ago, but
Oh yeah, sorry, it's Q536.
thank you very much.
And that's paragraph 50.
Yes, yes, I've got that. Yeah.
536.
Very good. All right. Well, look, I think the right thing for me to do is to make a ruling on this point at this stage, and then we'll see where we go from there. All right.
My lord, do you want me to respond to the last points or not?
Well, unless you've got any point that you additional point that you want to make, as I say, one of the factors that I think is relevant here, but neither of you have particularly focused on, whilst recognizing that there is a distinction, it is the distinction between whether the court has the power to do what it did on the one hand, and what it does as a matter of judgment in looking at the merits and exercising its discretion on the other. Because I'm inclined to think that that is a distinction of some importance. Whether it matters in this context is another question. But if either of you want to say anything further about that, now's your opportunity.
Yes, so we have 6 reasons why the worldwide freezing injunction should be vacated. None of them go to the court's discretion. All of them go to power/jurisdiction.
Well, I don't think that's right, Mr. Pacifica, but anyway, I take your point.
Yes.
I take your point, right? Mr. Bohr, is there anything you want to say about that?
Nothing to add from my side other than we say the court clearly has power and also shouldn't exercise its discretion. The only points I was going to add is that even if Mr. Pacifica is right about the Kuwait proceedings, and we say he's not right, those the original proceedings were dismissed, I think would be the correct technical term, although they were reinstated. But they were dismissed in February or March, actually, 2022. But there was no compliance even prior to that. So even on his best case, they were in contempt until that point. But it's a very poor case, and there are a number of reasons for that. But I'm not going to go into. The only point I will say is that you would have gathered that there are French proceedings for which the injunction was also continued, and that was brought to your attention at the return date. Those are still in place. My learned friend Skeleton does not deal with that at all, and neither does any of his evidence that from his clients. So those are the only additional points I would make.
All right. Well, thank you both very much. As I say, I'll now make a ruling on the initial question. The first question that this court has to decide is whether the defendant's application for discharge of the worldwide freezing order and disclosure orders can be heard at all. This arises in circumstances where, for a period of about 9 months, the defendants chose to ignore the proceedings which had been brought by the claimants in this court and the orders made by this court pursuant to the applications made. The position today is that the defendants offer no apology of any kind for disobeying the court's orders, have made no attempt in any way to purge their contempt by compliance with those orders, and show no willingness to pay any attention to anything this court says, should it determine matters in a manner adverse to them. The court granted an ex parte worldwide freezing order on the 10th of November 2021 with a return date of the 25th of November for an inter partes hearing. The defendants chose not to attend that inter partes hearing and to make any submissions, whether in relation to the court's power to grant the injunctions in question, or in relation to the question whether, if there was such power, the orders should have been made. There was no application to discharge or vary the injunction in any way. Despite the fact that the defendants had instructed lawyers in Kuwait and the USA, with whom, on the evidence, it appears they were in contact, the only reason given for not appearing to contest the grant of the injunction is to be found in the second defendant's first affidavit at paragraphs 79 and 80. There, the second defendant says this: when the WFI proceedings were initiated, I did not pay them due attention, as I believed them to be another piece of frivolous litigation initiated by the claimant. I genuinely expected that the WFI would also be dismissed in a manner similar to the underlying Kuwaiti proceedings, if not for any other reason, at least because the defendants had no connection with the DIFC. Unfortunately, the WFI was issued, and FAWZI, my wife and sister, are now subject to a $45 million injunction in a jurisdiction in which we have no assets or any connection. ... unquote. The excuses put forward do not, in my judgment, constitute any good reason for ignoring the court's orders and disobeying them. And as is obvious from the evidence, by failing to disclose assets and then continuing to enjoy what appears to the court to be a luxurious lifestyle with substantial expenditure on travel and holidays and residences in different parts of the world. They chose to flout the orders of the court, no doubt on the basis they thought that they could do so with impunity. It is in this context that Mr. Pacifica, for the defendants, points this court to the decision of Lord Justice Potter in Motorola against Uzan, I should say. He places reliance in particular on paragraph 50, where the Lord Justice says this, quote, although more modern authority has made clear that the discretion of the court is free from constraints of such a categorized approach, the proposition that the court will hear a person in contempt when the purpose of his application is to appeal against the order disobedience to which has put him in contempt has the merit not only of good sense, it seems to us necessary to satisfy the considerations of fairness. Whether or not a party is in contempt of court by refusing to obey an order irregularly made, or one consequent upon and or ancillary to an order so made, the circumstances will be rare indeed where it can be right to shut him out from arguing an appeal or application to appeal against that order made in due time. Close quote. It is right, I think, in these circumstances also to refer to the preceding paragraphs, specifically paragraphs 40. 45 onwards. In paragraph 48, there is citation from Arab Monetary Fund against Hashim, and the dictum of Lord Bingham, who said this, referring to earlier authority, quote, "From those speeches, it is, I think, clear that it is wrong to take as a starting point the proposition that the court will not hear a party in contempt, and then to ask if the instant case falls within an exception to that general rule. It is preferable to ask whether, in the circumstances of an individual case, the interests of justice are best served by hearing a party in contempt or by refusing to do so, always bearing in mind the paramount importance which the court must attach to the prompt and unquestioning observance of court orders," unquote. The tension that exists between the dictum of Lord Justice Potter and Lord Bingham is apparent from comparing those two citations. Self-evidently, it is the interests of justice which must take paramount importance. The question which arises is one of fairness to the alleged contemnor in circumstances where there has been a deliberate flouting of orders in the past and no indication of any willingness to adhere to orders made in the future. When one reads all those paragraphs together, there is perhaps a degree of surprise in finding that Lord Justice Potter, who is generally known for his robust approach, taking the line that he actually did. I was referred then by counsel for the claimant to paragraph 150 of the Motorola case and to two other decisions. At paragraph 150, the court referred to the general rule in relation to interim relief in the form of freezing orders and the like, that there is no requirement for the claim ultimately to succeed, and the jurisdiction that the court had over the defendants, which was undoubted. It was a separate question as to whether it was expedient or inexpedient to grant the interim relief against the defendants. The court made it plain that they disagreed with the judge by holding it was inexpedient in the case of the second and third defendants, but that they had determined that the English court had no, they had determined that the English court did have jurisdiction over those defendants. The other two authorities to which I was referred by counsel for the claimants bear with me. Well, first a decision by Mr. Justice Sales, as he then was, in Paratus AMC Limited, and Mr. Anselm Lewis. I was taken to paragraph 5 of that decision, which made the point that the proper course for any defendant to take in circumstances such as these is to comply with the order and apply for a variation of it. In this case, there would have been no difficulty in filing an acknowledgement of service, contesting the jurisdiction, and making the necessary applications for variation or discharge at any point without acceding to the jurisdiction of the court. The primary opportunity, of course, arose on the return date, when it is perfectly possible for a defendant to appear before the court, argue its case, and not accede to the jurisdiction at all. It is said, paragraph 5, that in a case where a party was ordered to make a payment into a court, there was no justification for failing to do so, and that compliance should have taken place, followed by the application to set aside. Rather similarly, in a further decision of Mr. Justice Garnham in Murley Merchandani against Alka Giwela and Augusta Ventures Limited, the judge at paragraphs 36 to 38 set out the general principles which apply to orders which are made and the approach of defendants in relation to them. There he said this, setting out what he characterized as, quote, the proper approach, unquote. Paragraph 36. As a freezing orders against is to be noted that this application in the Augusta proceedings to set aside the order of 20th of March follows an inter partes hearing before Mr. Justice Morris on that date. The application to set aside the orders of 29 July, 31 July, 19 August 2019, obtained on the application of Ms. Giwala, are late applications following hearings of which Mr. Merchandani had notice but did not attend. 37. The proper approach to such applications was considered by the Court of Appeal in Chanel Limited against F.W. Woolworth & Co. Limited, 1981, 1WR 485. There the court held, quote, the defendants are seeking a rehearing on evidence which, or much of which, so far as one can tell, they could have adduced on the earlier occasion if they'd sought an adequate adjournment, which they would probably have obtained. Even in interlocutory matters, a party cannot fight over again a battle which has already been fought unless there's been some significant change of circumstances, or the party has become aware of facts which he could not reasonably have known or found out in time for the first encounter. The fact that he capitulated at the first encounter cannot improve a party's position, unquote. And then at paragraph 38, there is a citation from Mr. Justice Popplewell, as he then was, in Orb against Bruhan. And there he said this, quote, the principle is well established and often applied in relation to contested interlocutory hearings. It is that if a point is open to a party on an interlocutory application and is not pursued, then the applicant cannot take the point at a subsequent interlocutory hearing in relation to the same or similar relief, absent a significant and material change of circumstances, or his becoming aware of facts which he did not know and could not reasonably have discovered at the time of the first hearing. It is based on the principle that a party must bring forward in argument all points reasonably available to him at the first opportunity, and that to allow him to take them serially in subsequent applications would permit abuse and obstruct the efficacy of the judicial process by undermining the necessary finality of unappealed interlocutory decisions. Close quote. Whilst I bear in mind the dictum of Lord Justice Potter in Motorola against Uzan at paragraph 50, that an appeal against an order of which a person is in contempt may be heard while that person is still in apparent contempt, where common fairness requires it, the situation here is somewhat difficult and militates against that course. Common fairness, as so described, does not allow a general challenge to the orders which have existed now for a year or more, in circumstances where the defendants have had every opportunity in the past to raise such challenges and have failed to do so. A freezing injunction is made on the basis of, inter alia, a good arguable case, a risk of dissipation of assets, without any final determination of the merits by the court. Had the defendants wished to challenge that, they should have done so long since, rather than ignore the court's orders, which has only reinforced the perception of the risk of dissipation of assets. But where a party does not participate without good reasons, there are inferences which can and ordinarily are drawn about its ability to refute the allegations which are made against it. The court must, when hearing such applications, satisfy itself that it has jurisdiction to make the order in question, and any reading of the material served with the freezing injunction would show that first, the court had not only required the claimant to produce additional submissions in writing on the subject of jurisdiction, but that the court had also carefully considered the matter. The court explored the nature of the claim and the requirement for a good arguable case with counsel, as well as the risk of dissipation and the justice and convenience of making an order, with particular regard to its worldwide nature and the lack of connection to the DIFC. In those circumstances, it is clear in my judgment that a defendant could not properly have concluded that the court would dismiss the claim for a worldwide freezing injunction as frivolous, nor treat the underlying claim as frivolous, nor dismiss the application because of a lack of connection with the DIFC, the excuses which are put forward by the second defendant for failure to participate. Advised by lawyers, as the defendants doubtless were, on receipt of the materials that the court required to be served on them on an ex parte basis, they chose not to appear at the inter partes hearing. Whether after taking local lawyer advice or not is unknown. After the inter partes injunction was issued on the 30th of November, they then took no action to challenge the injunction on any basis until the claimants had brought on the 1st of August 2022, some 9 months later, an application for committal for contempt. That was the obvious catalyst for action on the defendant's part. It was then, on 24th of August 2022, that the defendant filed an acknowledgement of service stating an intention to contest jurisdiction, and at the same time applied to vacate the worldwide freezing order of 30th November 2021 on a number of grounds which are set out in the application. The defendants have chosen to advance no explanation for their conduct other than that to which I have already referred, no apology of any kind, and made no attempt to purge their contempt by obeying the orders, nor said anything to this court about a willingness to obey any part of them. Whilst there may be no submission to the jurisdiction as such, the delay in seeking to challenge an order of this kind at an inter partes hearing designed for that purpose, or even to communicate with the court at all, whilst deliberately ignoring its orders, means that the court starts from the position where it has already considered the issues of jurisdiction, good arguable case, risk of dissipation, justice and convenience, and has decided that there are sufficient grounds to justify an injunction in circumstances where the defendants then decide not to participate in the proceedings. Unlike Uzan, this is not an appeal from an order made by an inferior court. This is an application made to the same court that has already granted the injunction having given the defendants a full opportunity to appear at an inter partes hearing to argue the issues which they chose not then to take up. It is said now on behalf of the defendants that there is a material change of circumstances because one set of Kuwaiti proceedings has been dismissed, namely the proceedings which were relied on by the claimants when seeking the injunction numbered 12850/21. It is, however, clear on the evidence of both the Kuwaiti lawyers instructed by the parties that these proceedings were dismissed on the 21st of February 2022 because of the inability of the claimants to serve one particular defendant party to them, called Cooke, with the result that fresh proceedings, numbered 4701/2022, were issued in virtually identical form on 20th March 2022, without that particular party as defendant. There is therefore no material change which favours the defendant. The latter case has now been referred to the Department of Experts by the Kuwaiti court, with substantive proceedings in Kuwait continuing and now substantive proceedings in France, to which the worldwide freezing order is an adjunct. There is no material change of circumstances favouring the defendant, which could justify the defendants approaching the court to challenge the grant of the injunction on the basis upon which it was granted. If the dismissal of 12850/20/21 in Kuwait had in any event constituted a material change of circumstances, any application should have been made at that stage, but it was not. And as soon as the proceedings numbered 4701/22 were issued, it could be seen that there was no material change in circumstances at all. Much the same sort of point arises in relation to the other Kuwaiti proceedings, 18977/21, which, although dismissed at first instance in April 2022, a decision which has been upheld on appeal on 3rd July 2022, they are now before the Court of Cassation with arguments as to the form of proceedings rather than the substance, in circumstances where, on the evidence, if the decision is then adverse to the claimants, fresh proceedings in the form required by that court will then be instituted. The effect of all of this, in my judgment, is this. Unless the defendant can establish that there is no jurisdiction in the court at all to grant a worldwide freezing order of the kind in question, on the grounds set out in attachment A to its written submissions, no challenge should now be heard by this court without the defendants first purging their contempt. There is, in my judgment, a distinction to be drawn between the jurisdiction of the court to make a particular order and the other matters which go to questions of expediency or inexpediency to make such an order, a distinction referred to in the authorities that I have already mentioned. It is only if the defendant can show that the court had no power to grant the worldwide freezing order at all that issues of contempt could possibly be disregarded pro tem. It is still good law that whether or not an order was properly made, it remains contempt to disobey it. The defendant cannot now challenge the injunction on the usual tests for granting such injunctions, such as the need to show a good arguable case of real risk of dissipation, or that it was just and convenient to grant the order, since the court has long since been satisfied of that, and it is now too late for the defendant to challenge it without first purging their contempt. Therefore, in these circumstances, I'm persuaded that I should deal with the jurisdictional question the fundamental question of jurisdictional power to make a worldwide freezing order when the defendants are said not to be subject to the court's in personam jurisdiction, which is the essential point which is taken by counsel for the defendants. If the defendants are right about that, whilst it does not excuse the contempt which remains, the point should nonetheless be explored, since it is a root and branch reason why the injunction should not have been granted in the first place, and would be a material factor in determining what the consequences of any such contempt should be. I therefore invite the parties to address me on the question of the court's power to grant a worldwide freezing order of the kind in question.
Thank you, Judge. I would propose to do that as we speak and move my application on the grounds the court has identified.
Yes.
I see it as 1 p.m. now, just to flag for the court. If we are to conclude at 4 p.m. Gulf Standard Time, which I assume is noon London time, we may go into a second day because there are very complicated issues to be explored. But perhaps I'll proceed with my application, and if the court please stop me if I'm being too verbose.
Well, I doubt if they are that complex at the end of the day. Particularly bearing in mind they're matters that I've had to explore before.
Yes.
My understanding is this: we've got 4 hours, haven't we?
Yes.
Yes. I can't see any reason why we shouldn't finish the matter today on that basis. No doubt we'll need to take a short break for the court staff after about 2 hours. I was thinking probably we'd take quarter of an hour or something at that stage, but that I think is all we need to do. I mean, you can take it, Mr. Pacifico, as I'm sure you're aware that I'm pretty familiar with the territory.
Oh yes, I've read both judgments in Jones and Jones. I've also seen the video of you questioning Mr. Montague-Smith and Mr. Hill precisely about these points. So I'm very well that the court is very familiar with this case. It was only 2 months ago, so I don't want to go over ground.
No, I mean, if the reality of this, Mr. Pacifica, is that you can predict the outcome of your application, and you're really pursuing this with a view to an appeal to a higher court,
No, Judge, I believe I can persuade you of my perspective, and I would like the opportunity to try to persuade you of my perspective. But of course, I'm very conscious of what the court is saying. So to open my application, I think there are 3 terms the court has used. I think first is jurisdiction, second is power, and third is expediency. And I think those terms are all slightly different. And I think the court has said that I can make arguments on the basis of jurisdiction and power, but I can't make arguments in respect of expediency. I think if that's
well, let me tell you what shall I tell you what I meant by that? If it wasn't clear, please. I hoped it was. The basis of your argument as set out in, I think, what you've described as attachment A to supplementary submissions on jurisdiction. It's that I have in mind, that it seems you're free to argue, which relates basically to what you described as the court's in personam jurisdiction. And that's the point that I had in mind. Everything else, it seems to me, does go to expediency.
Well, I would submit that everything else goes to power. And in this respect, can I draw the court's attention to the decision of Lords Scott and Forey and LaRue? And that's at Q742. This is an important distinction that is made. It's at paragraph 25 of the judgment, and Forey and LaRue is a decision of the House of Lords from 2007. And Lord Scott says at paragraph 25, if the court has it before it, both the deputy judge referred to the issue as one of jurisdiction. But jurisdiction is a word of some ambiguity. The ambiguity was referred to Lord Justice Pickford, and here's the quote. The first And in my opinion, the only real correct sense of the expression that the court has no jurisdiction is that it has no power to deal with and decide the dispute as to the subject matter before it, no matter in what form or by whom it is raised. But there is another sense in which it, i.e. jurisdiction, is often used, i.e. that the court has power to decide the question. It will not, according to its settled practice, do so, except in a certain way and under certain circumstances. Yeah. So to take the latter line there, that's a question of power. Now, it's not a question of jurisdiction, and there's a distinction to be drawn.
That depends how you use the expression.
Of course.
The way I've used it is in relation to the first sentence.
Can I draw the following examples, and this potentially highlights the principle to the court. Suppose one party issues proceedings against another party in England, two English companies, matter of English law, and suppose that that party seeks judgment for £5 million in England. Can that party then go to the DIFC and seek a worldwide freezing injunction in the sum of £50 million? So again, there's a £5 million claim in England, and can you get a worldwide freezing injunction in the sum of 50 million in the DIFC? And I think the answer to that question is clearly no. Clearly, the court has no power to do that. So in that sense, I would use that as that would be the issue of power. And I think it's those issues which I want to address. Now, I know the court is very keen to push me on to attachment A, but I would submit the issue of power very much is dealt with in the other points that I'm making before the court. They're not issues of expediency. I'm not saying the court should have exercised its discretion in another way. I'm saying the court did not have the power to do what it did.
Well, I don't follow that argument.
Well, could I make?
Can I just ask you a question?
Yes.
In the context of the example that you give, it would be a wrong exercise of the court's powers to grant a freezing order for something which does not represent a good arguable case on the part of the claimant.
Yes.
But that's the point. It's a wrong way to exercise the jurisdiction. It's not a question of does the court have the jurisdiction to do it. And in the judgment I've just given, I was using jurisdiction in that sense, and I think, and I hope I did, specifically referred to the attachment to your skeleton as being the area that I thought it was open to you to argue at this stage. So,
I suppose, obviously, to collect my client's permission, to protect my client's position, I want to make all the arguments that it is possible for me to make.
I understand that.
And obviously, those. Yes.
Go on,
so
go on, Mr. I'm sorry. One of the problems of Zoom is that we constantly interrupt each other, and it becomes very difficult, and we can't get the usual interchange. But you finish what you were going to say, I'll then interrupt again.
But I have 6 reasons as to why the court should vacate the injunction. Now, my submission is that all of those 6 go to jurisdiction and go to power. They do not go to expediency. And I think that actually has consistently been our case. So perhaps maybe, obviously, if the court is not with me on this, I fully accept that. Perhaps I should just very concisely go through those 6 issues and try to persuade the court that these, besides attachment A, these issues also go to the question of jurisdiction and power. To give another example, now perhaps this may highlight the point. The court is very well aware that defamation is not recognized in the DIFC. It's not part of the DIFC law of obligations. So suppose a party issues proceedings in England for defamation, and there's a good arguable case, there's a judgment that you can recognize. Could a party then go to the DIFC and get a worldwide freezing injunction in support of the defamation action in the United Kingdom? And I think the answer is clearly no. The DIFC cannot, I suppose, enhance its own powers based on wrongs that are not recognized in the DIFC but are recognized in other jurisdictions. So this really is the point I'm making with respect to reflective loss. So it's very clear from Mr. Boer's argument and the way in which he presented the injunction that he is in fact making a claim for reflective loss. His underlying or overarching argument is that UEL has lost money. That's the Cayman entity. SANDRA Holding is a shareholder of UEL, and because UEL has lost money, SANDRA Holding has therefore lost money. That is a claim for reflective loss. In Mr. Boer's most recent skeleton argument, which I can draw the court to, he concedes that his claim in Kuwait is as a matter of Kuwaiti law. And I think the court will be aware that reflective loss, or the bar on recovering reflective loss, was recently recognized in the DIFC. So Mr. Boer is making a claim for reflective loss. It's a claim that cannot possibly be made in the DIFC, and the DIFC is granting an injunction in respect of reflective loss. Now, I would say that goes completely to power and to jurisdiction. It doesn't go to expediency. There are no circumstances in which it would ever be expedient for the DIFC to grant a worldwide freezing injunction in respect of defamation. Likewise, in respect of reflective loss, it's not about balancing matters of fairness. It goes directly to power. So that's what I mean by power and jurisdiction. And I would ask the court to allow me to make those arguments, because I believe I can convince the court that my arguments go to power, not to expediency. If I can. I hope the court can indulge me. And obviously, if the court is not with me, the court is not with me. I fully accept that, but I would like to try to persuade the court. Now, there are 6 reasons why we say the worldwide freezing injunction should be set aside. And the first thing that we say is that the underlying Kuwaiti proceedings, 12850, are not sufficient to warrant a worldwide freezing injunction, because those proceedings do not and never have sought a money judgment. And then, of course, those proceedings have been dismissed. That again goes to power. Civil investigatory proceedings in Kuwait, where you're seeking the appointment of an expert, can never warrant a freezing injunction in the DIFC. Our second point is that the Kuwaiti courts are not courts of competent jurisdiction, and they're not courts of competent jurisdiction to resolve a dispute regarding Universal Enterprises Limited, a Cayman entity. Again, that goes to power. The third point that we're making is that the Kuwaiti proceedings are an illegitimate interference with the liquidation of Universal Enterprises Limited. In fact, this liquidation of Universal Enterprises Limited is currently being supervised by the Cayman court. And in effect, what SANDRA Holding and the claimant are doing is they are stepping into the shoes of the liquidator and essentially performing functions that are the liquidator's functions. They are going directly against the entire process in Cayman that is being supervised by the Cayman court, and where 2 liquidators from Ernst & Young have been appointed. Is
that merely a reflection of the reflective loss point?
Well, I think it acts on both sides of it. So obviously, prior to a liquidation, then there's a principle of no reflective loss.
Yeah.
But once a liquidation happens, the liquidators then control the company. And again, it's for the liquidators to do it. So yes, they're very much interrelated.
Yeah.
I would say. The fourth point we make, of course, is the reflective loss. I want to get into the case law on that. And then the final point we make is that the Kuwaiti proceedings advance claims that are statute barred. And again, they would never warrant the injunction. And of course, the final issue is the issue of in personam jurisdiction in Jones & Jones. As I said, I have read both judgments in Jones & Jones. I have watched the 4-hour hearing between your lordship, Mr. Montague Smith and Mr. Hill. I
bet that was fun.
It was on double speed, so it was fine. So I'm very familiar with how the court is thinking on that. I have very concise submissions to make on that. I fully accept that it is a somewhat courageous position, given that judgment was only made 2 months ago, but I would like to make it, I think, in fairness to my own clients and in fairness to Mr. Boer's clients.
Yeah.
So,
well, look, Mr. I'm sorry, I keep pronouncing your name wrong as well. Pacifica, it is, isn't it?
Pacifica, perfect.
Yeah, I'm sorry. In the judgment that I've just given, I specifically said, I'm just checking my notes, but I think the transcript will show that the effect of what I was deciding was that you need to establish that there's no jurisdiction in the court at all on the ground set out in attachment A to your written submissions. So that I've already decided that.
Okay,
if what I will do is very briefly say something about the different heads that you've already put. But I have determined that, and so the reality is you're confined now to arguing your attachment A. But so far as the other points are concerned, let me just say this. If one's looking at the other issues that are raised, they all relate to the substantive cause of action which is taking place in Kuwait or in France. It is not as if this court is dealing with the substantive merits at all. The whole basis upon which the injunction was granted was in support of foreign proceedings, where the cause of action had to be established according to the law in that jurisdiction. So whether one's looking at reflective loss, whether one's looking at underlying proceedings and their nature in relation to a case which can result in the end in a money judgment, whether or not that is currently being sought, whether or not the Kuwait courts are courts of competent jurisdiction, whether the Kuwait proceedings are an inadmissible interference with the Cayman Islands liquidation, and whether or not there's their statute barred, are all matters for the Kuwaiti court to decide. So that if the Kuwaiti court were to dismiss all proceedings, then of course the ground for that ground as a basis for granting the worldwide freezing injunction would disappear. Likewise, if the French proceedings completely disappeared, that too would constitute a ground. But none of that, in my judgment, goes to the issue of the power of the court to grant an injunction of the kind in question, and the limitation that I have imposed by my earlier ruling is that you should be able to argue only that the court simply has no power at all to grant the injunction in question on the basis of the arguments in your attachment A.
Could I would disagree with the court in that sense, and just if the court,
I'm sure.
which would just here's how I quote with the court. So, in Motorola and Uzan, here's what happened. There were proceedings in New York. The claimant then sought an injunction in support of those foreign proceedings in the United Kingdom. They were granted. The defendants then attempted to set it aside, and of course they were unsuccessful setting it aside, but it was ultimately set aside in the Court of Appeal. Now, one of the grounds that the High Court judge, Mr. Justice David Steele, whose decision was overturned, but one of the reasons he said that you can't set aside the injunction is he said, look, everything is taking place in New York. I can't second guess what's going on in New York. I can only make an order that is reflective of what is going on in New York. He also referred to Henderson and Henderson. Again, the duty to raise arguments. This is what Mr. Justice David Steele said. The English Court of Appeal fundamentally disagreed with Mr. Justice David Steele. And the English Court of Appeal specifically said, we have to, on our own initiative, consider whether or not those foreign proceedings are legitimate and whether or not those foreign proceedings warrant the relief sought. For example, is New York a court of competent jurisdiction? In Motorola and Uzan, the English Court of Appeal specifically examined whether or not it was a court of competent jurisdiction. Likewise, it examined as a matter of English law whether or not the reliefs, the substantive reliefs sought in New York would be available in England. So what I would say is it is not only is it preferable, I think it is the duty of a court granting an injunction in support of foreign proceedings to examine the legitimacy of those foreign proceedings and whether or not those foreign proceedings, if instituted in the DIFC, would give rise to the relief claimed. There's also a recent DIFC case precisely on this point, which is Arabian Construction and Credit Suisse. Now, it's in our bundle, but just to highlight the facts, essentially Arabian Construction sought recognition of a Kuwaiti judgment in the DIFC. The DIFC Court of First Instance refused to recognize the judgment, and likewise the Court of Appeal refused to recognize the judgment. And the grounds on which they refused to recognize the judgment was that Kuwait was not a court of competent jurisdiction. So in other words,
that's fundamental in recognition cases.
Well, of course, and likewise, it's fundamental in granting injunctions in support of foreign proceedings. It's the same principles, the very same principles apply. And my authority for that is the English Court of Appeal in Motorola and Uzan, a leading Court of Appeal case. Perhaps could I take the court, because I think that's the fundamental issue here. I'm trying to persuade the court that it has to examine the foreign proceedings. It can't effectively blindly accept them.
What the test it would be applying at a freezing injunction stage would be the good arguable case point, wouldn't it?
Well, it depends what we mean by good arguable case. And in particular, I'd refer the court to the very recent Privy Council case in Broad Idea. And in that case, Lord Justice Leggett makes very clear that it's a freezing injunction is not ancillary to a cause of action. So, for example, we say breach of contract, that's a good arguable case. Mr. Justice Leggett says, no, that's not what's going on. A freezing injunction has to be ancillary to a money judgment, prospective or obtained. And you have to have a good arguable case for being granted a money judgment. Yeah. That effectively is the gravamen of Broad Idea. And so the point that I'm making here is there is no good arguable case the claimants have advanced for a money judgment, particularly because their underlying proceedings, the Kuwaiti proceedings, don't seek a money judgment. And so they don't even get out of the first hurdle in accordance with Broad Idea. And one other point which I just need to flag, and I think Mr. Bohr, for the first time in his skeleton argument served last Wednesday, is now saying that the worldwide freezing injunction is in fact based on proceedings in France. Just to outline what's happened, the claimants were granted a worldwide freezing injunction in November. They then attempted to recognize that worldwide freezing injunction in France. So the idea that the worldwide freezing injunction is now grounded on French proceedings, I mean, it's as if saying the worldwide freezing injunction is grounded on itself. It's sort of a tautology.
Well, that's not quite right, Mr. Pacifico, is it? As a matter of history, what you say is right about the injunction being granted in support of substantive Kuwaiti proceedings, which have been dismissed but reinstigated in the form that I referred to in my earlier ruling. In addition, now, apart from the effort to enforce, if you want to put it that way, the Moreau injunction in France, there are now substantive proceedings in France. That's a new development, isn't it?
Well, yes. So there's two sets of proceedings in France.
Yes, exactly.
But again, the second set of proceedings were only commenced in April.
Yes.
Again, they weren't commenced when the WFI was made. And again, the key authority that I hope to rely on today was Faure and Leroux. And it says, Faure and Leroux precisely says, if you get an injunction, you need to identify the prospective judgment ab initio. The commencement of new proceedings after the injunction has been granted or after it's been dismissed will not save the injunction. So that's the key point that I wanted to make today.
Can I raise a point of fact just on this? I don't mean to be rude and interrupt my learned friend, but in fact, in our second skeleton argument for the return date, paragraphs 3.1 to 3.4, which is at page 41, we explained to the court that additional proceedings had been issued in Kuwait and France. So by the time the injunction was made, was continued after the return date, there were French proceedings, and those proceedings were not just for attachments. They were, I believe, criminal/civil proceedings.
So they weren't. Sorry, Mr. Boyle, they weren't. They were not. In that respect, I might refer the court to page B56 of the authorities, and this is the affidavit of the claimant's French lawyer. It's the first witness statement of the claimant's French lawyer. Yeah. And at paragraph 2.1, Mr. Savoy says, quote unquote, "I can confirm we have commenced taking steps in France, quote unquote, to enforce the worldwide freezing order." Quote, and then it follows saying the claimants do not intend to seek relief in France, which is superior to the relief given by the WFO. So it's just to make this point, when the worldwide freezing injunction was granted on the 30th of November, there was only one basis, and that's proceedings 12850. I don't think there's any written document or any oral submissions made by Mr. Boer in which he says we're now granting it on these French proceedings. But the French proceedings were simply an application to recognize the WFO or WFI in France. So I cannot see how an application to recognize a worldwide freezing injunction can itself ground a worldwide freezing injunction.
You may want to look at page L408, which is this first affidavit of the French lawyer, Mr. Savoy, where he explains, I'm looking at paragraph 2.1 of his statement, where he talks about the French proceedings.
What's the date of that? I don't want to get into a dialogue, Mr. Board, but this is the affidavit.
Well, I don't want to get into the dialogue, but I obviously can't stand by when you're saying things which don't seem to be correct just on the basis of his statement. So if it's his first affidavit, it's page L408. If you have the PDF, it's page 4514.
L408.
Yeah.
Which paragraph are you looking at?
Paragraph 2.1 onwards.
So this is an affidavit prepared on the 21st of October 2022. This is prepared very recently.
That's right. And he gives you an outline of everything that's taken place.
The affidavit that I was referring to is the contemporaneous one. It's the affidavit, it's the witness statement that was before the court before the 30th of November, and before the the question here, I think, for the court and for Mr. Boer is what is the basis of the WFI? Now, I think it's very clear that the basis of the WFI are Kuwaiti proceedings 12850. There is now a new argument which is being made by Mr. Boer for the very first time that in fact they were grounded by French proceedings. But as of the 30th of November, the only French proceedings which were in being were French proceedings seeking to recognize and enforce the WFI. So I just don't see how the French proceedings can possibly give rise to the WFI. It's a tautology, it's circular. I mean, the WFI grounds itself.
If you look at the first witness statement, I think you were on the 23rd of November from Mr. Pierre-Olivier Savoy. If you look at paragraph 3.1, you'll see he refers to substantive proceedings in France.
But those substantive proceedings hadn't been commenced.
On the 23rd of November, my law firm filed for the initiation of substantive proceedings on behalf of the claimants against the defendants before the public prosecutor.
But they're criminal proceedings. Again, those criminal proceedings can't give rise to a
WFI. The French claim is both the criminal and civil component.
Sorry, Mr. White, I don't want to get into a dialogue, but the evidence is quite clear. There was a criminal complaint was filed. When the criminal complaint was rejected, civil proceedings in France were then issued.
There isn't a dialogue. That's what he says at paragraph 3.2.
Well, let's just have one of you talking at a time. Mr. Boer, you can reserve your position and come back on what if you think that there's a misrepresentation of the evidence. But let's hear what Mr. Pacifica has to say.
So as a statement of principle, the symptoms I would make as follows. A worldwide freezing injunction, in light of the Privy Council's decision in Broad Idea, needs to be based on a money judgment, prospective or obtained. And that is the judgment of the Broad Idea, and that was accepted by your lordship as forming part of DIFC law, I think, in the most recent case of Jones and Jones. Now, this issue of what constitutes a money judgment has been addressed on multiple occasions by the English courts. And the most notable authority in that respect is the decision of the House of Lords in Forey and LaRue. Now, in that case, the facts were as follows. A liquidator was appointed over several South African companies. Once the liquidator was appointed, the liquidator was suspicious that wrongdoing had taken place. The liquidator then sought and obtained an ex parte worldwide freezing injunction in the High Court in London. And when the liquidator obtained that injunction, the liquidator did not have in mind specific proceedings.
Mr. Krasipko, you are now not arguing on attachment A.
Okay, I accept.
I'm not. There is no point in going down this line, because I've already decided that it's only the attachment A arguments that are open to you at this stage until you purge your contempt.
Okay, I think that's very clear. The court obviously does not want me to address it on quantum or anything like that.
Yeah, well, I mean, I think as it happens, I think there's some very good answers to the points you're raising, but they're not points which it's open to you to argue at this stage.
Okay.
You're only open to you to argue that the court had no power at all to do what it did.
I would say that my submissions are on power, but of course the court is not with me on that. I will move on. I think that's the only thing I can do.
It is the only thing you could do. I have decided.
Apologies. I apologise, Judge. Again, I'm simply trying to.
Power in this sense is power to make the order, and
yes.
That the basis upon which you are contending that the court has no power, in the sense that I've used the word, are the grounds that are set out in attachment A. So let's restrict ourselves to attachment A.
I apologise, Judge. It was only to represent my clients to my fullest ability, or at least to get our arguments across.
Let me just say this for your benefit. I fully understand that your clients have a series of points they wish to make, and that you are doing your best to present all those arguments. But I've decided that some of those points are simply not open to them at this stage. If they wish to appeal, that's a matter for them. But that's the view that I've taken.
All right, that's very well understood. So moving on to attachment A, in the 4-hour hearing in Jones and Jones, your lordship asked Mr. Hill a very interesting question, which is this. It was, why can't the DIFC court have the jurisdiction against anyone worldwide? I mean, it doesn't have to exercise the jurisdiction, but why can't it have that jurisdiction? And I think there are a few answers to that question. And I think that the simplest answer is this, is that it potentially weakens the procedural protections available to defendants or to respondents to worldwide freezing injunctions. Worldwide freezing injunctions arose in a context of in personam jurisdiction. The foundation stone of worldwide freezing injunctions across the common law world, from England to the BVI to Hong Kong, is in personam jurisdiction. Now, in that respect, I'd like to refer the court to my skeleton argument, because I think that's essentially where all of these authorities are gathered. Could I refer the court to page Q216?
I've printed off your skeleton as it happens, so if you can give me the internal page number as well, that would help.
Yes, so it would be internal page 46.
Thank you.
And this is a paragraph, I think, 2.3 towards the bottom page, and it's an extract from Dicey.
Yes.
And where the authors state, the basis for the development of the worldwide freezing injunction was the recognition that the freezing injunction operates in persona, and that where the defendant is subject to the personal jurisdiction of the court, an injunction may be granted in appropriate circumstances to control activities abroad. Likewise, this was subsequently endorsed by the House of Lords in Forey and the Rue. And again, where Lord Scott states, quote unquote, he summarizes all of the authorities. And he says, these authorities show, in my opinion, that, and the key passage is underlined, provided the court has in personam jurisdiction over the person against whom an injunction, whether interlocutory or final, is sought, the court has jurisdiction in the strict sense to grant it. Again, I think I read Lord Scott's his definition of jurisdiction in the strict sense, and in the wider sense, maybe more talking about power. So again, the necessary condition for granting a worldwide freezing injunction is in personam jurisdiction. Now, likewise, we go then to broad idea, which is the decision of the Privy Council, and the very recent decision. And again, I think the court has endorsed that the decision of Lord Leggett in Jones and Jones. And in the conclusion, Lord Leggett concludes, for the reasons stated in this judgment, it is the decision of the board that underlined where the court has personal jurisdiction over a party, the court has power, and goes on to grant a freezing injunction. So the very, very, I think the necessary condition across the common law world to grant freezing injunction is in personam jurisdiction. And this case is also highlighted in Motorola and Uzan. And what I think it would be appropriate just to go to that judgment, it's not in my written submissions on this point. Could I refer the court to Q540? And towards the end of the page, and again, this is paragraph 68 at the bottom, Q450, paragraph 68. And there's an article cited, and it's referred to by Lord Justice Millett. And it says, quote unquote, this is the top of page Q541, for an English court to enjoin a person properly subject to its jurisdiction from disposing of assets abroad cannot in the sense be regarded as exorbitant. Perhaps in Republic of Haiti and Duvalier, and I think the court might be familiar with that case. That was Mr. Duvalier, who was accused of expropriating assets from Haiti. But it says goes to the very edge of what is permissible. For the sole connection of England with that case was the presence in England of solicitors with access to the foreign assets. The exercise of jurisdiction can be justified on the basis that the solicitors could be treated as agents as the defendants, and the relevant information was located in England. So in the Duvalier case, which is the high watermark of the court's jurisdiction to grant an injunction in support of foreign proceedings, there still needed to be an in personam connection to England. And the connection was simply that solicitors were acting as Mr. Duvalier's agents. So in England, in the BVI and in Hong Kong, in personam jurisdiction is a necessary condition. The entire gravamen or ratio of broad idea is that, and broad idea has, I think, partly been endorsed by your lordship in Jones and Jones, but the entire basis of a worldwide freezing injunction is having in personam jurisdiction. And I would say that your lordship's decision in Jones and Jones, and obviously, unfortunately, this is a rather courageous position for me to take, but I think it goes beyond what the Privy Council allows in broad idea. Because in broad idea itself, the Privy Council was very, very careful to preserve the in personam requirement. So the question then arises, what is in personam jurisdiction in the DIFC? Now, the court will be very much aware that service of proceedings is no basis on which to ground jurisdiction in the DIFC. Essentially, there is no procedure in the DIFC rules that requires permission to serve out of the jurisdiction. So on that basis, if the court were to conclude that simply service is the basis for in personam jurisdiction, I think obviously every single individual in the world, no matter where they reside, would be subject to the court's in personam jurisdiction. I think that can't possibly be the case. It can't possibly be the case that every person in the world is subject to the DIFC court's in personam jurisdiction. So we have to fall back on Article 5 of the Judicial Authority Law. And it's my submission, and I think the court again is very familiar with Part 25, 24 of the rules of the DIFC courts. This simply recognizes, so it seems, I think, to recognize a pre-existing power to grant an injunction in support of foreign proceedings. I accept what the court has ruled, the court's decision in Jones and Jones, but what I would say is there's no basis whatsoever that Part 25, 24 can confer in personam jurisdiction on every person in the world. And I think we're stuck with Article 5 of the Judicial Authority Law. And again, so that's, I think, the positive answer. But the normative answer is this, is that if a court can grant a freezing injunction against parties not subject to its in personam jurisdiction, that significantly weakens the procedural protections available to those parties. For example, you would much prefer, as a defendant, to be subject to a freezing injunction in a jurisdiction in which you're familiar with, a jurisdiction that you have a connection to, a jurisdiction where you potentially have assets, you potentially already have legal representation. To say that the DIFC has the authority to grant a freezing injunction against anyone in the world, I think both contradicts the judgment of the Privy Council and broad idea, but I think it's also normatively bad, because I think it does away with the procedural protections available to parties. So I suppose those are my submissions.
What do you say that when the court is thinking about granting an injunction, leave aside for the moment questions of quote in personam jurisdiction, but there are other restrictions, aren't there? The court will not grant an injunction where it has no utility.
Yes.
And the court will not grant an injunction where it feels it has no ability whatsoever to police it, enforce it, or anything of that kind. And I can't remember in this case, but I rather suspect I would have asked at the time the injunction was first sought, whether or not it could in any way be effective. And I suspect the answer would have been given to me, well, yes, it will, because even if we can't be sure that there are any assets in the DIFC, we know there are some in onshore Dubai, and the conduit jurisdiction allows one, therefore, to export the injunction and so on and so forth. But it's not as if the court simply assumes that it can order an injunction against anybody anywhere in the world, provided they get within 5A1, and in this case 5A1 little e. So it isn't quite as if the court is saying we can do anything we like for anybody at all anywhere in the world, is it?
Well, I suppose that the question I would have is what parties are not. So if the court accepts that a necessary condition to a freezing injunction is having in personam jurisdiction, and I don't think it's controversial that that's what the authorities say. You need in personam jurisdiction.
But the difficulty about that argument is this, and let me put it frankly to you and see what your response is. In personam jurisdiction is different from in rem jurisdiction in common law terms. That's the fundamental distinction. And it's self-evident that a freezing injunction does not give in rem rights. It gives simply rights against the persons against whom it's made. And so in that sense, it's an in personam remedy. But the phrase in personam otherwise has little relevance to DIFC law because, as you rightly say, jurisdiction's not founded on service. It's founded on simply, can you get within Article 5A? Yeah. And so to my mind, the only real question which arises is whether you get within 5A1 little e. And that then depends on construing the particular rule of court, which I've already held and the Court of Appeal has held to be a regulation. Yes. For the purposes of DIFC law. And the way I put it in Next, in the Court of Appeal, was that every one of the rules of court would have to be examined to see whether or not it was in fact conferring jurisdiction, or whether it was simply a rule which operated within the sphere of the other gateways. And yes, that's the construction point, isn't it? Yes. But it's not as if there's no limit at all on the court's power. You've got to get within 5A one way or another.
Well, my question, I think, firstly would be, well, what is the limitation? Because I think that is slightly unclear from the judgment of Jones and Jones. I mean, I think I think the way I'm framing my argument, I'm taking the assumption that a court needs in personam jurisdiction to grant a freezing injunction. And again, my authority for that is Dicey, my authority for that is the Privy Council, and my authority for that is the House of Lords. And these aren't isolated judgments. These are judgments spanning a long time. So that is the assumption that I'm making. Now, of course, the court is fully open to the court to say, well, that requirement doesn't apply in the DIFC. But then I just think the court should be conscious that it's not really endorsing broad idea. It's departing from broad idea. And I think Jones and Jones endorses broad idea in the sense it talks about the enforcement principle. But at the same time, it doesn't say that the other key requirement of in personam jurisdiction has been satisfied. So we essentially have an entirely different creature of injunction in the DIFC to what we have in the BVI, what we have in England, and what we have in Hong Kong. And maybe that is, of course, the way the court has gone, and because the DIFC is a different jurisdiction. But I would submit that that is an impermissibly broad jurisdiction. And I don't see how it is limited. It seems to me, I mean, I don't want to go back to the points I've already made, but it seems to me in this case, what we have is we have no in personam jurisdiction. We have no cause of action recognizable at DIFC law because it's a claim for reflective loss. And then likewise, I think Mr. Boer's permission, even though the injunction started on 12850, it's since migrated to several different other proceedings. I mean, that to an extent is a bit of a recipe for chaos. If you can grant an injunction against anyone in the world, there doesn't need to be a cause of action recognizable in the DIFC, and you can pick and choose your proceedings as you go along. I mean, if you lose one, you can launch another, you can launch another. I just think that doesn't sound fair and to my clients. I think the court. I mean, I haven't gone into the Siskina as well. I mean, and the court will be very much aware of Section 25 of the 1982 Act and how the position in the UK is statutory. There is no statutory basis in the DIFC. Now, of course, you could construe, as the court has done, Part 2524 as a statutory basis under Article 5(1)(e). And so potentially the court could say there is a statutory basis. But again, even if there is a statutory basis, in England, you still require personal jurisdiction. And that's the De Valier case. That's for in the Rue. So I think even if we had a statute in the DIFC, and even if I concede for the purposes of this argument that we do, and that is Part 2524 of the ORDC, still there's no personal jurisdiction.
Yes.
So I think I don't have the only other point I would just make is just to look at the actions of the defendants since the WFI was granted. So what they've done in Kuwait. So imagine this: they get an injunction. They issue proceedings in Kuwait, 12850. They then get an injunction in support of those proceedings in Dubai. That's the worldwide freezing injunction. But then 12850 are subsequently dismissed. But nevertheless, the claimants take the WFI predicated on 12850 and bring it back to Kuwait to enforce it. Like that strikes me as bizarre. Likewise, I mean, in the United States, again, the claimants, instead of trying to get the Kuwaiti proceedings recognized in the United States, that would be the appropriate thing to do. They're the substantive proceedings. They've attempted to basically latch on to the DIFC proceedings and then enforce the DIFC proceedings in the United States. And likewise with France. I mean, clearly, if Kuwait is the center of things, Kuwait should be substantive, and then they should take the substantive Kuwaiti proceedings to France, to the United States. And so they've gone completely through the DIFC. And the final thing is, and I think this is in my written submissions, and I don't want to labor it, but the Kuwaiti statement of claim is 4 pages long. It's a remarkable document. It's completely lacking in detail. I'm not sure the court saw it when the injunction was made, but the third and fourth defendants are now subject to a worldwide freezing injunction, even though they're mentioned in one line in this document. I mean, it's very unclear to me how the third and fourth defendants fit into all of this as well. So I suppose those are my submissions as to jurisdiction. Just taken as a whole, this is greatly unfair. No in personam jurisdiction, no clause of action recognised as a matter of DIFC law, and the claimants keep chopping and changing which proceedings the WFI is in fact grounded upon. And I don't know how we'll ever, if what the claimants say is correct, I don't know how we will ever vacate this WFI, because if another set of two sets of Kuwaiti proceedings with respect to UEL have already been dismissed, a third one is live, but they'll make another one and another one and another one, and this injunction will be here in perpetuity. So I have a lot to say on this, as you can tell, Judge.
But there is a simple answer to some of this, isn't there? If your clients obeyed the injunction or now purged their contempt, they could bring an application which could raise the sort of grounds that you've raised. In reality, there doesn't seem to be anything much that you can say about the Kuwaiti proceedings. Of course, if what has happened, and you say this is what has happened, the claimants have sought to export the freezing order and build on the back of that in other jurisdictions. In each case, that's been unsuccessful.
Well, the French proceedings are still ongoing, but
the French proceedings are now substantive proceedings. The attachment proceedings have failed, as I understand it.
No, they're both going on in parallel.
They're both still going on, are they? Well, okay, so be it. But those are matters for the foreign courts to deal with. If at the end of the day, the substantive proceedings, there are no valid substantive proceedings that are being conducted in either Kuwait or France, then of course the whole basis for this court's freezing injunction disappears. There's no question of pursuing a substantive cause of action in this jurisdiction at all. But your clients unfortunately start from the position that they have ignored everything this court has ever said, and therefore they can't be heard on some of the points they would wish to raise. But if they were now to purge their contempt, we might be looking at a different world, mightn't we?
Of course, I will certainly communicate that to my clients. But I think, again, these facts fall really squarely on Motorola and Uzan, because in that case, that's not only authority for the proposition about contempt, as we've discussed, a party can make the appeal, but in that very case, the defendants were permitted to argue that the United States court was not a court of competent jurisdiction. And the Court of Appeal specifically said it has to question the foreign proceedings and has to concern itself with whether or not those foreign proceedings are legitimate. And to freeze four parties' assets based on 4 pages, the first two pages mention the parties. The third page largely mentions the relief, which is the appointment of an expert. And there's really one page. There's no documents referred to or exhibited. There's no ownership structure. I just think it goes against fair procedures, but that's obvious. That's my submission on that.
Yes, well, thank you very much. Mr. Bohr, are there things you need to say? I mean,
I've got some very short points. I can make them, and I can make them very shortly, if I may. I mean, in terms of Duvalier, the broad idea case at tab 9 of Q, which is Q226, is the page I'm looking at. Page 8, para 18 of that broad idea case says quite expressly the power conferred by Section 25 is of enormous breadth. It's been exercised to grant a worldwide freezing injunction in connection with foreign proceedings against a foreign defendant with no known assets in England and Wales. And then there's a reference to Duvalier, where the only link with England and Wales was the fact that the defendant had used the services of an English solicitor.
Which paragraph are you looking at?
Paragraph 18.
Yeah.
Yes.
So there still was a link, I think, is the important point there.
Right, there was a link. So if one looks at paragraph 5.7a of my skeleton argument, I mentioned this connection. The defendant's connection to the FC is dealt with at NAS first 5.1. So we put in an affidavit which seeks to draw a connection or possible connection with the DIFC. And the point that I make here, which is still correct, and that is it's not being addressed by the claimants. And if one looks at page 62 of the bundle,
So which page, sorry, 62?
Which is it's page B20.
20.
So this, I believe, is NAS 1. There's a whole section on connection to the DIFC. And so this is not a case where there's no link at all or possible link to certainly to Dubai. But we're talking what we say here, what has been said here is that FAWZI and Ahmed established an investment company, the Budi Trust. And the registered activities include, and we list lots of things. It says, given the proximity to the DIFC, a major international commercial hub is possible. If not likely, the Sunday interest of Budi Trust investment will be channeled through the DIFC. And then we go on at 5.2. I won't read all this out. We make various other connections, business interests, the like. There's also a reference at 5.21 to Ahmed and Farah residing in Dubai. And it goes on. And the simple point is that there is here some possible prima facie link, and there's been no response to that whatsoever.
So I apologize, Mr. Board, but at paragraph 77 of Ahmed Al Saleh's first affidavit, he states categorically, I have no assets in the DIFC.
Right. Well, this is the point I'm going to come on to. This has not been, firstly, these particular allegations or comments have not been addressed at all. The point you just make doesn't really help us, Mr. Prasivka, because what we need to determine is what the situation was. Firstly, there's a query how much can be believed by a party in contempt, but we'll come back to that perhaps. But putting that aside, let's assume it's correct that there's no assets. Your clients have had a year to dissipate those. And what the affidavit does not tell us is what the position was at the time that this claim was commenced, this application was commenced. So there could well have been assets. And you talk about fairness, or my learned friend talks about fairness. What certainly isn't fair is for a party to hide behind its non-compliance with a court order, because we're not in a position to actually judge whether or not there are assets in or out of the DIFC at the time that the injunction was made. So in other words, even if, and my first point should have been, my lord, that Jones versus Jones is correct, Jones is the correct decision. It does, of course, rely on the Court of Appeal next decision, and it's correct. But even if, in fact, one needed to find some deeper connection as a matter of power and jurisdiction, well, we have that. We have that at the evidence I just took you to, and the failure of the defendants to respond to it. And indeed, even if one looks at the JAL, section 5A1C, where the court can have jurisdiction in a situation where the act has been partly performed in the DIFC. Again, in the absence of any evidence going to the cases that have been put, or indeed in response to the injunction, the court is entitled to say that there is a possibility that, in fact, some of the wrongdoings that's being alleged took place or was performed in the DIFC. I mean, my basic point is that the court cannot say that even if they needed some strong connection, or even if it needed to go under the JAL, which we say it wouldn't do, that in fact we could get home on that in any event. So those are the only points I was going to make in relation to that. The other point was just the correction point that I was going to make before. The French proceedings, substantive French proceedings, were on foot at the time of the continuation of the injunction, and that is made clear in the skeleton argument that we submitted for the return date. And it's made clear in the witness statements of Mr. Savoy, and indeed, as I mentioned in the first affidavit of Mr. Savoy, the more recent one, he gives a whole chronology in terms of the substantive proceedings. But that's just a point of correction. I don't have any other points, my lord.
Just one minor point just about the French proceedings. I think we do need to clear this. So essentially what happened, the first freezing injunction was made on the 10th of November. After that, proceedings were initiated in France to recognise the freezing injunction. So we'll call it the WFI recognition application was in place when a continuation order was made. Now, then The other substantive French claim was commenced on the 28th of April 2022.
You missed out something.
Well,
that's
not
not what Mr. Savoy says, is it?
I thought that's what he says. If I go to page L408 and at paragraph 2.2, sorry, it's L409, and this is the most recent one. On the 20th of April 22, the claimants filed a criminal complaint against the defendants. And that's the criminal complaint. And that criminal complaint has subsequently morphed into a civil complaint. But that criminal complaint was filed on the 28th of April 2022. So I don't know, Mr. Wise, apologies if I'm mistaken, but there are two French proceedings, is the way I understand it. There are recognition of the WFI, and then there is this substantive claim referred to here. There's not a third set of criminal proceedings, unless I'm missing something.
Well, if you just go back to paragraph 2.1, he says on the 23rd of November, filed for initiation of substantive proceedings in the form of a criminal complaint. And then in 2.2, he says that has a criminal and civil component. Once the criminal case is initiated, they will constitute themselves as civil parties in the criminal case. So
Yeah. And they proceeded.
I'm not sure I understand quite.
Well, it's also clearer than that, because it was made clear at the relevant time. In other words, prior to the return date. Because if one goes to B57, which is the first witness statement of Mr. Savoy, which is the one that Mr. Prasivka took you to originally, what he didn't take you to was section 3 of that statement, which is at B57, which makes the same point that has just been picked up in the affidavit.
Yes, so I fully acknowledge that there was a criminal complaint prior to the 30th of November 2021, but I'm saying there was no other civil complaint.
But you can see what it says at 3.2 at B57. The French claim has both a criminal and civil component.
But my understanding, just this is a point of French law, but my understanding is that these are separate. So you launch a French criminal proceedings first, then you wait for the prosecutor to take action. And then the prosecutor in this case decided not to take action. So then a civil complaint was filed in April.
Well, if you carry on the statement of B58, it explains to you the process. The French claim asks French prosecutorial authorities to initiate a criminal case. Once a criminal case is initiated against defendants, the claimants can and will constitute themselves as civil parties in a criminal case.
Yes, and they did that, but again, that was in April.
That's the point.
So I think there's an issue. This point of French law here is there was a criminal complaint certainly filed before. That criminal complaint has morphed into a civil complaint. And I think Mr. Bohr is contending there was always a civil complaint. And I disagree with that, but I think it's a matter of how you characterize the French law.
Yes, all right. Well, I've got the point. As I say, that might be a relevant feature on an application to set aside. But still, the court would be looking at the position as at both the date when it was granted, the injunction was granted, and as at the position as at today's date as to whether or not such an injunction should be maintained. Now, of course, I'm sympathetic, Mr. Pasivka, with the thought that a party shouldn't go around constantly instituting new proceedings in the hope of somehow validating an injunction that's already been granted. But the court would be very alive to that. And any arguments on that basis should a time come when they can properly be pursued. I think what I need to do now is to make a ruling in relation to the jurisdiction and attachment A arguments, and then we'll see where we go from there. We're now at 10 o'clock. Does the court need a 10-minute break at this point, Shayla, or what?
I'm okay, Your Honor. It's whatever the court deems appropriate at the moment. From my end, I'm okay.
Okay, and is that just a question really of the court staff? And I don't know if there's a transcriber present or who needs time out or anything of that kind. If not, we can just bat on.
We don't have a transcriber at the moment. We usually send the recording to the company and they transcribe it for us. So it's okay to proceed, I believe.
Okay. And when you send the recording to the transcriber, you'll probably need to send them the copies of the cases that I've referred to in the rulings I've made, because I've quoted various parts of them. But anyway, that's all in due course. All right. Well, I'll make a ruling now in relation to attachment A. In the light of my earlier ruling today, I now have to determine the issue as to whether or not there is a jurisdiction stroke power in the DIFC court to grant a worldwide freezing injunction on the basis of the arguments set out by the defendant in attachment A to its written submissions. I use the expression jurisdiction stroke power in the same way as I utilized it in my previous ruling, as going to the fundamental question whether the court has the ability to make the order in question, not whether it's appropriate that it should do so in the circumstances of the case. Here the position is, speaking broadly, as follows. First, none of the defendants is a DIFC establishment, and none has presence in the DIFC, and none of the gateways in Article 5A1 little a to little d of the JAL, the Judicial Authority Law, can be established. Secondly, there is no good evidence that the defendants have assets within the jurisdiction of the DIFC, although the claimant suspects that they may do, and there is evidence of assets in onshore Dubai. The question of the power of the court, in the sense I've used the word, the jurisdiction of the court to make such an order, is one on which the court specifically sought assistance from the claimant before issuing the worldwide freezing injunction on the 10th of November, receiving a supplementary skeleton argument on the subject on the 7th of November 2021. The area of contention is also the subject of a decision of this court on the 12th of September 2022 in Jones and Jones 2022 DIFC CFI 043, as well as a decision by Mr. Justice Wayne Martin at an earlier stage. Put shortly, the defendant's contention is that although the DIFC courts have the power to grant worldwide freezing orders in support of foreign proceedings, they do not have the power to grant such an injunction where the defendants in question are not subject to what is expressed as the court's, quote, in personam, close quote, jurisdiction. Counsel for the defendants praise and aid the two English decisions. The first is a decision of the House of Lords in the Susquehanna 1979 appeal cases 210. The second is a decision of the Privy Council in Broad Idea International against Convoy 2021 UK PC 24. It is also submitted that whereas the position in England in relation to jurisdiction to grant injunctions in aid of foreign proceedings is governed by statute, namely Section 25 of the Civil Jurisdiction and Judgment Act, there is no equivalent statute in the DIFC. It's common ground between the parties that the jurisdiction of the DIFC courts is statutory and does not depend on service of proceedings. The question therefore arises as to what is meant by, quote, in personam, in, quote, unquote, jurisdiction. If the court in the DIFC has jurisdiction or power to grant injunctions in the circumstances referred to, it must be found in the provisions of Article 5A(1) of the Judicial Authority Law, Bylaw number 12, 2004, as amended. Alternatively, reliance could be placed on the DIFC Courts Law, number 10 of 2006, but where there is a conflict, it is the Judicial Authority Law that takes precedence, as stated by the Court of Appeal in Deere against Waterfront Properties, 2009 DIFC CFI 011 at paragraph 61. The Judicial Authority Law provides as follows at 5A(1). The court shall have exclusive jurisdiction to hear and determine, and then at little e, any claim or action over which the courts have jurisdiction in accordance with DIFC laws and DIFC regulations. The court law provides at Article 19(1)(f) that the court shall have jurisdiction over any application over which the courts have jurisdiction in accordance with the DIFC law. In Next Investment Holdings, Lebanon SAL against Deloitte and Touche, DIFC CA011, 13th March 2019, the Court of Appeal concluded that the rules of the DIFC court constituted a DIFC regulation for the purpose of Article 5A(1)(e), and that Rule 20.7, which provided for the addition of a third party to an action, took effect where there was no other gateway under Article 5, which would be applicable to the claim against that party. That decision is binding on this court, inasmuch as it determined that the RDC constitute a DIFC regulation within the meaning of Article 5. But the question still arises as to the construction of any particular rule of court and whether it does confer jurisdiction or operates only within the sphere of the jurisdiction set out under the other gateways in Article 5. In the case of Rule 20.7, the Court of Appeal decided that the rule would be robbed of most of its force if it did not have the effect of conferring jurisdiction, and concluded that it did have that effect. RDC 25.24a is headed, quote, application for an interim remedy where there is no related claim, close quote. It provides as follows, open quote, where a party wishes to apply for an interim remedy, but, colon, 1, the remedy is sought in relation to proceedings which are taking place or will take place outside the DIFC, semicolon, or 2, the application is made for an order for production of documents or inspection of property before a claim is made, semicolon, any application must be made in accordance with Part 8. Article 32 of the Courts Law provides that the DIFC court has power to make orders and give directions as to the conduct of any proceedings before the DIFC court that it considers appropriate. This is a provision held to be materially identical with the effect of Section 37(1) of the Senior Courts Act 1981 in England, which gives the court a general power to make orders and grant injunctions where it's just and convenient to do so. Under Article 32 of the Courts Law, the power includes the grant of an injunction requiring an act to be done, interlocutory orders and ex parte orders, with the court empowered to determine when making such orders is appropriate. There is moreover, in Article 22 of the Court's law, a provision that the CFI may order an injunction restraining a person from engaging in particular conduct, may require a person to do a particular act, and may make such order as it considers appropriate. There is, however, no express statutory power given to the DIFC court in any law to make an order of the kind set out in Section 25 of the Civil Jurisdiction and Judgments Act in England to grant worldwide freezing injunctions in support of foreign proceedings. It is in this context that Rule 25 of the RDC falls to be considered. That provides expressly for interim remedies, including at RDC 25.6, freezing orders which refer to the removal of assets within the jurisdiction of the DIFC and dealing with assets whether inside or outside that jurisdiction. At Rule 25, bracket 7, close brackets, is included an order directing a party to provide information about the location of relevant assets or to provide information about relevant property or assets which are or might be the subject of an application for a freezing order, often referred to as a disclosure order. There then appears later in the Rule 25.24, which I have already quoted, and which expressly refers to interim remedies which are sought in relation to proceedings which are taking place or will take place outside the DIFC. The only question which arises is whether that power in relation to foreign proceedings is restricted by the other gateway provisions in Article 5. I can see no basis for any such restriction when Article 5A1E is an independent head of jurisdiction, unless the terms of the rule so suggest, and I can see every reason why there should be no such restriction. It is also established by case law in the DIFC that a claimant seeking a freezing order does not need to show the existence of assets within the jurisdiction in order to justify an order relating to assets outside the jurisdiction under RDC 25.6. B. In SEC against Wintercorp SA 2019 DIFC CFI 003 on 4th March 2019, the court at first instance granted a freezing order in aid of an interim order granted by a US district court, relying on the provisions that I've just mentioned. I myself have had cause to consider the width of the powers granted to the DIFC court in the context of applications for a freezing order relating to assets in onshore Dubai in aid of a claim being pursued or about to be pursued in the onshore Dubai court in circumstances where there was no gateway provision applying except arguably Article 5A1 little e. In that case, in Jones and Jones, there was an asset in the jurisdiction, but the vast majority of known assets were in onshore Dubai. It was submitted that the provisions relating to execution of a judgment only operated once such a judgment had been issued, which is self-evidently the case. But it was also submitted that the provisions for interim remedies in Article 21, Article 22.2, and Article 32.2, together with RDC 25.1 and 25.24 of the court law, did not provide any basis for jurisdiction. I'm sorry, I've confused that. I should say Article 22.2 and Article 32.2 of the court law, together with RDC 25.1 and 25.24, did not provide any basis for jurisdiction. In arguments in that case, it was pointed out by counsel that if Article 5A1 little a to little d could be satisfied, that in itself would constitute jurisdiction over the substantive claim itself, whereas RDC 25.24 specifically operated in relation to proceedings outside the DIFC. I found that it was hard to see how the rule could have any application at all in the absence of a power in the court to grant a worldwide freezing order or disclosure order in the circumstances expressly mentioned in the rule. I there dismissed arguments based on the Susquehanna and the limitation of English jurisdiction, which depend upon service of the proceedings on a defendant. The effect of the broad idea decision is to create greater latitude in that regard, and Justice Wayne Martin in Latif against Leela 2020 ARB 017 drew on that decision in reaching the conclusion he did, which preceded my decision but was identical. He reached the conclusion by reference to what was characterized as the enforcement principle, where there was no cause of action available in the jurisdiction in aid of which the freezing injunction or disclosure order was sought. The matter is discussed in greater detail in paragraphs 3 to 21 of my decision in Jones. There is no point in repeating the terms of those paragraphs to which reference can be made for the purpose of this judgment. There are good policy reasons, additionally, for making orders of the kind in question in cases of this kind, where fraud is alleged. Where fraud is involved, there is every reason for commercial courts operating in the international sphere to support foreign courts with jurisdiction over the substantive dispute in order to render any decision of such a court effective when it comes to recovery of sums adjudged to be due. The foreign court is, of course, the ruler of its own jurisdiction and the decision maker in relation to the validity of causes of action brought within it. And this court is not in a position in the ordinary way to say anything more than whether or not there is a good arguable case for such a cause of action to be pursued in that jurisdiction and under the governing law in question. I conclude that the court does have jurisdiction under Article 5A1e of the JAO and RDC 25.24 to grant worldwide freezing orders and disclosure orders in aid of proceedings in another jurisdiction such as Kuwait, without the need to bring the case within the provisions of Article 5A1a to d, and without the need for anything which might be characterized as, quote, in personam, in quote, jurisdiction, as envisaged in other common law countries. There are good policy reasons why this should be so, as already set out, and as illustrated by the Privy Council decision itself in broad idea and the decisions of this court in Latif and Jones and Jones. In those circumstances, this being the only basis upon which the defendants can currently challenge the worldwide freezing orders that have been made, their application must be dismissed. Right. What that leaves then is what to do in relation to the orders that have already been made and the application for contempt and the unless order that is now being sought by the claimants. I think probably what I need to do, Mr. Pacifico, is to ask you whether you have any instructions at all in relation to the contempt application itself or the alternative unless order that's being sought.
And perhaps could I ask for a 5-minute recess to consult
Yes.
internally?
Yes,
Perhaps
well, I think that would make sense. Are you in a position? I'm not quite. You're in Dubai yourself.
I'm in
understand,
Dubai, yes.
But where do you have ready access to your clients?
I'd have to check. I don't know is the simple answer. Could I suggest perhaps a 5-minute recess that would take it to 2:35 Dubai time, which I assume is 10:35 London time?
Yes, if you need a little bit more than that, you can have it. Let's say 10 minutes, which will give me the chance to get myself a cup of coffee, if nothing else.
Perfect.
10 minutes. All right. Thank you very much. Is everybody ready to proceed?
Yes, Judge.
Yes. Do you want to say anything, Mr. Pacifico, or what?
No, unfortunately, I haven't been able to obtain any additional instructions from my client, so I'll proceed in accordance with how the court wishes.
Right. Well, Mr. Ball, where do you want to go from here?
Well, on the set-aside application, I mean, our understanding is there's nothing left in relation to that. In light of the finding that there's been no material change circumstances and that the court had jurisdiction.
I dismissed the application, yes.
Yes. So it's really just the contempt application that's remaining.
Yes.
And so I'd like to make that application. I don't know, Mr. Pacific can respond to that.
Yes. What I'm asking you, though, is whether you're pursuing a contempt application per se, or whether you're pursuing an unless order.
Yes, I mean, my instructions, I believe, unless I'm just going to look at my WhatsApp, is that to pursue the contempt application.
Well, what point is what's the purpose of the unless application?
The unless application was relevant. We made, just in terms of history, the other side made a set-aside application. We made an unless order application in relation to that at that point in time, in the hope that the court could deal with that as a preliminary matter even prior to hearing the set-aside application and make an unless order. And then if the injunction had been complied with, then the set-aside application could be heard. As it happens, your lordship made a direction that everything should be heard together. So, and in a sense, what's happened today is that the set-aside has substantially been dealt with. So the unless order application essentially falls away. It's no longer needed in relation to the set-aside application. So the only thing that's really remaining now is the contempt application.
Yes. Yes.
So in relation to that,
yeah.
I was just going to continue and start launching into that, but your lordship wants to.
Yes, no, I'm sorry, I'm just reflecting for a moment. Yes, well, I think you better launch into your application, and then I'll hear what Mr. Pacifica has to say about it.
Yes, well, the case we would rely on is Latif, the decision of Justice Wayne Martin, which you can find at Q tab 2, and it starts at Q21. And in particular, if one reads paragraphs 10 onwards.
Oh, wait a minute.
Yes.
What did you say? What's Q what?
Well, Q23, it's Q tab 2 is where you can find the case, but Q23 starts the section that I'd like to draw your attention to.
Okay. Yeah. This is
This is the case of Latif, which is Sir Justice Wayne Martin. Justice Wayne Martin, sorry.
This is the second bit of Latif, is it?
I believe so. I'm not very familiar with the first bit, but it's the contempt application.
Yes.
And so you can see that foot of Q23, the general principles are set out. Many of these have been summarized in my skeleton argument, and this was a very helpful decision. There's reference to the VIH. I won't read out every paragraph because it'll be tedious to do so. So you may just want to cast your eyes over from 10 to paragraph 19.
10 to 19?
Yes.
Yep, okay, just let me do that. Yeah.
While we're on this case, we should also look at paragraph 141 onwards, which deals with the principles that apply to penalties.
141?
Yes.
Yeah.
Our application notice, which I'll just draw your attention to, just so you can see that's in the correct form, is it's I5, which is page 3212 of the bundle.
I'm sorry, Mr. Paul, what are you referring to now? I was just reading 141. Just
sorry, yes. So I was just going to ask you to just look at paragraph 141 and that section which deals with the guidance in relation to penalties.
Yes.
So the principles include the serious and deliberate breach of a court order may well merit imprisonment. B, breach of court order is always serious because it undermines the administration of justice. C, a deliberate and substantial breach of a freezing order, which is what we're dealing with here, is a serious matter which normally attracts an immediate custodial sentence. And D is particularly relevant where there is a continuing failure to disclose relevant information. The court should consider imposing a long sentence. Then E lists mitigatory factors, which includes an immediate admission of breach, an admission of the seriousness of the breach, cooperation in order to mitigate the consequence of the breach, and a sincere apology to the court. And the court will note that actually none of these mitigatory factors are present in this case. In fact, what you have is a statement that the injunction was ignored because it was believed to be frivolous. No apology and no suggestion that the order will be complied with even if you made any finding against these defendants. So those are the principles. I was going to take you next to our application notice, which is at I5 of the bundle, which is, if you're using PDF, 3212. Please do let me know when you have located that.
Yeah. Yes.
actually it starts at I3, and I'm taking this just to show you for good order that we've complied with everything with RD 52.9. In other words, everything that needs to be in here is in here.
Yes.
We've listed the particulars of the contempt, the grounds on which we're applying. We've listed the defendants, and we've applied the usual wording that's in the schedule for the rules in relation to the warning about the seriousness of this, including the statement that if you consider the allegations, I'm looking at page I5, if you consider the allegations are not true, you must tell the court why. If it is established that they are true, you must tell the court of any good reason why they do not amount to a contempt of court, or if they do, why you should not be punished. And then there's a recommendation to take advice from a legal representative, which appears to have been done, but we've had no suggestion that the allegations are untrue. They clearly are true.
So yes, we have. It's just set out fully in the affidavit of Ahmed. The first section deals entirely with the substance.
Well, I'll come on to that in a little while. The other point to point out in relation to all this, if one looks at page 4697, I'll give you the internal reference in a moment. It's the email from the court. So it's page 001 of the bundle.
Yes.
This is dated the 12th of September, so it's some time ago from the DIFC court's registry. And these are instructions which your lordship gave to the parties. And point 3 is pertinent to the present application. Additionally, it says the defendant should be informed that unless and until any order of the DIFC court is discharged, it's a contempt to ignore it or disobey it, and such contempt has to be purged. And then you make the point that the application has been around for 9 months, and the recommendation is given that the defendant should take counsel's advice on the consequence of that contempt on their application to the court and the individual position of each defendant, regardless of any dispute as to the court's jurisdiction. And we say that the court is being very generous here by making it very clear to the defendants what the consequences of them continuing in the breach would be. And we say, in a sense, it aggravates the breach as well, because this email has been completely ignored. I don't believe it's addressed at all in my learned friend's skeleton argument. There's no explanation as to why the defendants have simply ignored this instruction or direction. The other points that I make are really set out at paragraph 4.9 of my skeleton argument, and I simply list the various breaches and therefore the basis for the contempt application, and say at 4.10 that it's also inconceivable that the defendants have not spent money in breach of the WFO, and nothing in their evidence suggests that they have preserved $45 million or any assets. And while we're on that, it's worth noting that Mr. Smith, in his third statement, which is at page 94 of the bundle, and this is page B52, so this is a witness statement filed prior to the return date. He has a section there at section 3 entitled "Potential Breach of the Freezing Order."
Yeah.
And he refers to a letter in Arabic about restructuring, which without any proper commercial or legal basis. And then there's a background to the letter, a bit more background at paragraph 3.3. This letter itself is at page C2211, which is PDF page 2313.
It's a B55, isn't it?
Well, the letter I've got is I'm looking at the one at C2211. You're saying B55.
I imagine it's the same.
Yeah, I think so. Well, it's dated the 14th of the 11th. Yeah. So it comes very close on the heels of the injunction being made. And suddenly there's this restructuring, which Mr. Smith explains that the second claimant knows nothing about, and it all looks very suspicious. But even without this, I mean, our point is that given the fact there's been no compliance whatsoever, engagement, apology, any of the mitigatory factors, then the court is entitled to, and particularly in the lack of any defence whatsoever in relation to this, conclude that actually the substantive order in relation to freezing has also not been complied with. So, I mean, the other question
as to what extent.
Well, we just don't know the answer to that. We simply don't know, and that's probably why we would submit the English court takes such a strong view against failure to disclose, because without that, a claimant or claimants in our position are simply left in the dark. They don't know. Assets could have been dissipated during the entire time since the order has been made. We've got no idea how much assets the defendants have, where they're located, and all the other information that should have been given almost immediately or within a very short space of time following the grant of the order. And so that's why it is such a serious thing. The only other point I was going to make in relation to the contempt itself is there are some additional factors here, in addition to the ones that I've mentioned already. Not only has there been nothing, there's been some fairly, we would say, rude reactions to the order in terms of blocking WhatsApp, for example, in terms of service, and the statement about these proceedings being frivolous, we say really don't help the defendant's position and should also be taken into account. But the point of the fact is there is no defence at all to the contempt. I think it's only paragraph 71 of my learned friend Skeleton where he addresses that point.
So 7.1.
So it's, yeah, 7.1, sorry, not 71. So there's a reference to the primary defence is that the various disclosure orders should never have been made. Well, the court's already determined that point, and that's it. That's the entirety of the defence. And then there's the secondary point is in relation to the 250,000, which says it'd be unfair to allow, I'm summarising, but it says on the claimants filed an application for an arrest order, such an order will require the defence to pay 250,000 for the privilege of being allowed to argue the WFO should not have been made in the first place. Such proposition is manifestly unfair, but of course it isn't manifestly unfair, because even if the defendants could have shown today that the order should be discharged and they could have made that application, and for all the reasons that we pointed out in our skeleton and has been said today, that would never go anywhere in any event. But even if that were the case, the very fact that they failed to appear or even notify the court or engage in any way whatsoever with the claimants would have warranted an order to pay the $250,000 of wasted costs. And that is absolutely fair. And it's unfair, in fact, that they haven't paid it and we're out of pocket. And that's even if they were right, but of course we say they're not. So that's all I was going to say in relation to that. I don't know whether to stop there and see if Mr. Prasifka wants to respond to any of that before dealing with penalty.
Well, I suppose our position is as follows. Now, I don't want to preempt any matters, but I will be making an application for permission to appeal the various orders. Obviously, I think while this is technically an interlocutory application, there is some finality to it. And what I simply would say in respect of costs or in respect of anything with respect to contempt, firstly, the position of my client is set out in his affidavit at paragraph 71 onwards. I would remind the court that we have been subject to something like 25 proceedings from the claimants. We have no connection with the DIFC. It was necessary to engage this firm, or at least certainly our team within this firm on the very first the very first time. So I would ask for to have some sympathy for my client's permission, or my client's situation. But what I would be asking is if the court were minded to grant us permission to appeal, to stay any penalty pending the outcome of that appeal. And I think just to make one point very clear as well, and this is at Q24, I think it's all parties agree that the DIFC court does not have jurisdiction to make a sentence of imprisonment. I mean, I think that's, I don't think that's beyond.
No, it has to go to the Attorney General.
Yes. Now, obviously, if there is a matter referred to onshore Dubai, then obviously issues of jurisdiction do arise. And again, so I think perhaps it would be, this is obvious, this point with respect to in personam jurisdiction. I think the court has acknowledged in its judgment that though the authorities say in personam jurisdiction is required, that the DIFC is in a different position. I would submit that potentially that needs to be resolved by the Court of Appeal. Because it is a I suppose a point of law of general public importance, or at least importance within the DIFC. So I think my primary application would be to stay any orders in respect ancillary to a finding of contempt pending an appeal.
Well, if I may respond to that,
there's a sorry. To a point, there may be an interrelationship between any application for a stay and the nature of any penalty that might be imposed.
Of course.
So I think I'd like to hear a bit more. It's not for the claimant to tell the court what penalties are to be imposed. That would be like a criminal case where counsel tells the court what the punishment should be. But I would value some guidance in relation to prior authority. The point, in a sense, is very obvious. If I were to refer this matter to the Attorney General with a view to him considering whether or not imprisonment was an appropriate sanction, what is in practice the effect of that? My recollection is that in USAN, periods of imprisonment were imposed for, I think it was a year. I'm maybe wrong, but I think it was a year. For, of course, defendants who were never ever going to come within the jurisdiction. And quite how that would work in the current context, were an imprisonment sanction thought appropriate, I don't know. The second and fourth defendants are said to have a residence in onshore Dubai. The first defendant, as I understand it, is an 86 or 87-year-old. He said not to be terribly well, but he conducts business and presumably gets about the world a bit, I don't know. But there are questions of effectiveness, utility, and everything else. And at the end of the day, what happened in USAN? Did the court simply impose an enormous fine?
My understanding, in USAN, there were 4 separate defendants. Yes. And each separate defendant was then sentenced to a term of imprisonment. They were different according to each defendant. And then there was an application to vacate the contempt orders and the underlying freezing injunction. That failed. And then this went to the Court of Appeal. And perhaps I could draw the court's attention, really, it's right at the end. What happened in the end was that, so 2 of the defendants succeeded in vacating the worldwide freezing injunction. And as a consequence of that, their terms of imprisonment were also vacated.
And were they fined in the end?
I'm reluctant to give, I don't believe so, but I just would like to check that point. I don't believe so.
I mean, what I would have expected, and one's expectations are often confounded, but on the face of it, regardless of the discharge of the freezing injunctions, they were, of course, in contempt, because during the time when the injunctions had existed, they'd failed to pay any attention to them. So I would have expected there to be some sanction, but it may be that the court took the view that having imposed a section of imprisonment, which was doubtless ineffective because they never turned up within the jurisdiction, the court may have thought, well, what's the point, and decided to do nothing. But the other two, presumably, simply remained subject to a sentence of imprisonment, did they?
I'd have to check. I mean, if we go to page 560 of the this is really the conclusion.
Can you give me a?
So Q560 and so
Q560. Thank you.
Q560, yeah. Sorry, and then it's paragraph 157.
157. Yeah.
Paragraph 157, and this is just simply the conclusion. It's right at the end of it. This is essentially reciting what happened. So I don't believe. I mean, obviously it's a long judgment, but I don't believe any fine was imposed on them. Simply, I think simply what happened.
Deferred. There you are. Look, the
Yeah.
findings of contempt will stand. The question of any penalty we substituted will be deferred for further submission.
Yes.
So,
but
presumably the Court of Appeal decided that what was the appropriate penalty, rather than going back to, I think it was Mr. Justice Gross, wasn't it, to impose the sentences, as I recall.
Yes.
As he then was. I'm being absolutely blunt and frank. What is the point of this court referring matters to the Attorney General in relation to a potential sentence of imprisonment when it can be assumed that if that were to stand, none of the relevant defendants would set foot within the jurisdiction of onshore or offshore Dubai? My inclination would be to think that in those circumstances, a much more salutary and effective penalty would be a significant fine. And my recollection of fines in this context has been that they have been enormous. But again, I'm looking for guidance. I'm not looking for the parties to tell me what I should do, but I'm looking for guidance as to what sort of levels of fine have been imposed for offences of this kind. When I say offences, I mean contempt of this kind.
Well, I don't have any cases in relation to the level of fine. And even if I did, I suspect there'd be English law cases, and there may not be contemporary ones, many of them.
Well, you see, I think there have been cases, and I may be wrong about this because my memory is faulty, but I think there have been cases around the time of Uzan and since, where some very salutary and significant fines have been imposed.
Yes, well, I'd have to look those up, I'm afraid.
Well,
yes.
Okay, well, let's stop there for a moment. But perhaps it's a question I need to ask Mr. Prasivka. In the context of mitigation, which you're obviously entitled to make, what do you say an appropriate penalty would be, leaving aside your application for stay for a moment?
Well, firstly, I think it's very clear that the DIFC court has no power to have a term of imprisonment, and I think that's VIH. So there's no restriction. So I think we're all clear on that. Now, there is no authority that I am aware of, or I think Mr. Bora is aware of, within the DIFC quantifying the level of a fine. So obviously, I mean, my position, I think, would be as follows, and this is just taken as a whole. To be, firstly, we would apply for leave to appeal. I think that would be given how all of these various orders overlap, I think it would be to appeal all of the orders. And I think secondly, then what we would be saying is, with respect to the order, I think your lordship indicated that potentially having to pay 250,000 in costs as effectively a price to purge the contempt could be too much, or it could not, but it had not indicated that. I thought the court had indicated that potentially that So then secondly, what I would like the court to do is effectively to set out what is the precise price my clients have to pay in order to be heard on their entire application. And I'd like that to be reflected in the order.
Well, that's very easy. That's very easy, isn't it? Because the price they have to pay is to obey the orders which have already been made. That would purge the contempt.
And does that include the costs order? Because it's unclear whether it's unclear because there's a costs order, and again, it's a matter for the claimants to enforce that. It's unclear whether that is a price they have to pay in order to purge contempt.
If you're going to purge your contempt, you have to comply with each provision of the orders made against you, which requires full disclosure of assets. And that requires full disclosure of assets at the time of the injunction being granted. It would also inevitably now require disclosure of assets as at today worldwide. And if there has been a dissipation of assets, there would have to be a full and frank, candid admission of dissipation of assets and stating where they've gone to. In a sense, it's hard to tell what is total purgation until you know exactly what has happened. But basically, purgation means putting right what you've done wrong.
I fully accept that. I would say that when the final order is drafted, I think I would like the court and Mr. Bohr Mr. Bohr to be very, very specific about what is required of my clients in order to purge the contempt.
I don't think one can do that.
Okay. Accept that.
The ordinary position is this, Mr. Pacifica, that a party comes before the court and offers to purge its contempt by doing various things, and the court then says, yes, that's good enough, or no, it's not good enough. But as I say, it's absolutely fundamental in the present case that you'd have to obey the orders. The reason I referred to 250,000 is that in a sense that's less important than the disclosure of assets, which is what the claimant originally wanted and what was originally ordered. It's only a question of which is more important, but you'd have to obey the orders and you'd have to put right everything that has gone wrong in terms of disobedience to those orders. And it would be for you to advise your clients as to what that is in the light of the facts as they're revealed to you by our clients as to what they haven't done with their assets in the interim period. So that's as far as that goes. But so far as punishment is concerned, I mean, I'd be very surprised if there weren't some indicia in authorities as to appropriate levels of fines in the context of a case of this kind. And I'm reasonably confident that fines were imposed in Usan, probably on those two defendants who had failed to obey the orders, but where they were discharged. And dredging my memory, which is doubtless faulty, I think it was the order of £50,000 each. And of course, we're looking at a rather more, we're looking at a different position here where there's been no discharge. And one of the reasons why, as you would have heard from my original ruling, one of the reasons for wanting to hear the jurisdiction point, was that it would plainly impact upon any level of punishment. Because if the order was wrongfully granted in the first place, that impacts on the degree of culpability for not obeying it. Doesn't excuse it, but it impacts on it. If neither of you are in a position to give me any guidance on that, my inclination would be to adjourn for you to do that. Tell you frankly, my current thinking is that there is little point in me referring this matter to the Attorney General in relation to questions of imprisonment. and that a substantial fine is a much more appropriate sanction to adopt. That's how I currently see it. But in order to make it a sufficiently salutary, it would have to be a very significant sum. And you're entitled to mitigate on that, Mr. Prosivka, but it has to be in the context really of talking figures.
Yes.
Now, can either of you help me further on that, or is the sensible thing simply to adjourn for you to take instructions, look at the authorities, and come back to me? And if necessary, we can do this tomorrow, can't we? What's the position on the listing here? Was this
we have, I think, tomorrow morning as well. You're in Dubai time, I believe.
Yes,
well,
there's a second day in reserve.
Is that right? I have something else on tomorrow, I see, but I'm not quite sure what it is or what time it is.
And it's not here.
Shayla, do you happen to know what time my other matter is tomorrow?
I am checking, Your Honor. I believe it's at. Is it the TCD 003 matter?
I could tell you what it's called.
That would help, but I'm not sure if it could be a private case. I could just check the system if you would allow me a few seconds.
It's a CFI case. It's 051/2022. It's Zaya Living Real Estate Development against.
Yes, it starts at 1 p.m. Dubai time, which I believe is 11.
9 o'clock.
No, sorry, 9 o'clock. 9 o'clock.
9
UK
o'clock
time.
English time.
Yes.
And how long is that down for? Do you know?
For the rest of the day, so until 4 or 5 p.m. Dubai time.
4 hours. Yeah. Oh, actually, it's down for more than that, according to my.
If the issue is simply a figure, perhaps this could be done by way of written submissions.
Yes, except that I think you may want to say more.
Yes.
When you've got a contempt application, this is serious business, and I don't think it ought to be dealt with in writing. I think it should be dealt with formally, and you have every chance to say whatever you think you need to say by way of mitigation, particularly if I'm thinking of imposing something quite significant. I mean, the overall context of this case, it's not as if any of these people are struggling for cash. From what I understand, we're talking about people of significant assets and substantial wealth. And that inevitably means that if a fine is going to be imposed, it's got to be one which hurts in some way.
In terms of practicalities, I think it would be a good idea for us to go away and think about levels of fine. But yes. in terms of the principle, I would suggest that imprisonment would be appropriate because the defendants clearly have been concerned about this. They've only appeared when a contempt application has been made. And they therefore seem to be scared. There is also some evidence, and I took you to Mr. Smith's third witness statement, paragraph 3.1, in relation to connection to Dubai. There is some suggestion that there are visits, frequent visits to Dubai. There may well be extradition possible within the Middle East. And therefore, it may be something that the defendants really don't want, and it may bring them into compliance. In fact, even more perhaps than a fine, which they could simply not pay. I mean, they haven't shown much willingness so far to pay costs, for example. Why would it be any different in relation to a fine? One might speculate. Of course, there's nothing to stop the court making more than one, giving more than one penalty. And one could even, you mentioned that the first defendant is elderly. A fine may be appropriate in relation to him, or indeed all of them, but particular sentences in relation to the others.
Sorry, Mr. Board, but I mean, at page Q24, there is the authority VHI Dubai Pam Jumeirah judgment of Sir Richard Field, which states specifically that the DIFC does not have power to
yes,
make that order. I thought we'd
agree.
agree. I thought we'd agreed that, and I didn't.
We are agreed that.
Nobody's saying anything different, Mr.
No, I'm just simply saying
Sefka.
it's a matter whether it's been referred to the Attorney General of Dubai for that purpose. So we're in agreement with what you just said, or whether in fact the DIFC impose a fine. And I'm simply saying the DIFC can do both, or can impose different penalties on in different parties. That's the point I'm making, and I think and the court may want to consider that. I mean, as you say, we can't tell the court what to do, but we can make some suggestions in terms of the factors that the court should have regards to. So, I mean, my simple point is that there may well be value in referring the matter to the AG, given the way that the defendants have reacted to this. They've taken it relatively seriously. I mean, I say relatively because it's an extraordinary thing to be in a hearing where the only defense to a contempt application is in relation to the appeal, is we want to appeal it, when in fact there's no substantive defense at all. I mean, that's the answer. So, I mean, on that basis alone, the court, should be thinking very seriously. We would submit in terms of the penalty. But so coming back to your practical question, my lord, I think it would be useful for us to have some time just to look at what courts have ordered in terms of fines, if that can be gleaned.
Well, there are two options in that respect. Either we can adjourn now for an hour or something and come back in an hour's time. Where are we now? There's still time for that. It's 3:20, as it did in Dubai, and can't come back at say 4:15 or something of that kind when you've had a chance to look at it. The oddity is this, Mr. Bohr and Mr. Pasifka, that if all I do is refer the matter to the Attorney General, for consideration of imprisonment, this court has lost all control of what sentence might be passed, hasn't it? How does it work?
It also brings up issues with the Joint Judicial Committee as well. I think if I should flag that as well.
Well, what does the Attorney General do once it's been referred to him? Is what my real question is. Does Justice Sir Richard Field explain how the procedure works?
I haven't seen that in the case when I had a brief look at it.
Well, I would like to explore this, because if the matter comes back to the court with the Attorney General appearing and so on, that's one thing. But this court has no criminal powers of any kind. It can impose civil fines, but as I understand the position, and tell me if I'm wrong, you're both practitioners in the DIFC, once I refer the matter to the Attorney General, I essentially have lost all control as to an appropriate sanction.
Yes, I believe that's the case.
It must then rest with the Attorney General and the courts of onshore Dubai.
Yes.
Which is why I wonder, I don't quite see how the JJC then comes into it at all. But if that's what happens, it's a matter for them. And I need to be careful how I express this, but criminal penalties in onshore Dubai are very different from criminal penalties elsewhere in common law jurisdictions. And for this court to lose any control on that in terms of what might be regarded by this court as unduly severe would be unfortunate. Whereas if I impose fines, then I have control over this procedure. And indeed, the parties can go to the Court of Appeal if they think I've got it wrong. I think we need to adjourn. The only question is whether we adjourn simply for an hour for you to have a look at it and come back to me with a bit more information and an educated view, or whether we adjourn till tomorrow.
I would suggest returning till tomorrow for an hour, perhaps.
Yes,
Because
we need more
given
time.
that last point you made. And I'm told on the Latif case that the reference was made to the referral to the Attorney General was given.
Yes, by Wayne Martin, Justice Wayne Martin, but
yes,
he may. Perhaps I've had slightly more experience of the onshore criminal courts than he has.
I mean, the point we'd make now is that I'm glancing at G in relation to penalties and
Yes.
factors that the court takes into account. I mean, we are in this case in a territory where almost every one of the considerations.
I understand that, Mr. Ball. This is on its face quite an extreme case in terms of failure to observe disclosure orders and also potential failure in the context of dissipation of assets.
Yes.
Depends what you make of the 14th of November letter and what actually happened thereafter, which is an unknown.
Yes. I mean, the one concern I have is how much information we're going to be able to glean just from looking at cases in terms of references to the AG of Dubai, because things may happen behind the scenes. For example, the AG may make his own inquiries with the court for information, take some guidance from them. I don't know.
It doesn't work like that.
No.
I have no way of
yes,
tapping into any other system of any kind.
Yes.
Which is, and indeed, I think it would be wrong for me to do so.
Yes.
It seems to me everything has to be dealt with absolutely in open court in this court, and whatever order I make has the consequences it has. All right. Well, look, I think what I'll do then is I'll adjourn this till the same time tomorrow, which will give us an hour tomorrow before I go on to deal with my other matter. And you can each come before the court and make such submissions as you wish. And that may give you some opportunity to take instructions from the defendants as well. You've got a bit more time to do that.
Right. Thank you, Judge.
Judge, is there anything else we can usefully do today, or would it be useful for the court to do today? For example, in relation to costs of today, or costs, or the appeal point that my learned friend wants to raise?
Well, at present, I don't see any basis upon which I would stay any penalty pending the outcome of the appeal, because whatever the penalty is that's imposed, it's not one that's going to, so to speak, operate immediately, in the sense that although if I were to impose a fine, it would be payable immediately. I doubt whether the defendants would pay it if they had an appeal pending, though they plainly should. But
and are they going to? I might take it that they're going to be given permission to appeal.
No, they're not going to be given permission to appeal. They'll have to apply for it elsewhere, I'm afraid.
Yes.
Could
I make submissions on that point, or the court has made its decision, I assume? Yes.
Well, I've given you an indication, but of course you can make submissions. Make submissions now is probably the right time for you to do that. Will you?
Well, I accept it if the court is not with me, but I would say that this case does go to the very heart of the DIFC court's jurisdiction. I mean, essentially what's happened to my clients is they've got no presence within the DIFC. They're not subject to its in personam jurisdiction. The cause of action is unknown inside the DIFC, and the basis of the worldwide freezing injunction is continually changing. So obviously, in those circumstances, I believe, and then also given, I mean, this is technically an interlocutory matter, but in reality, given it's an injunction in support of foreign proceedings, in reality, it is a substantive matter, at least as far as the DIFC is concerned. And so in those circumstances, I think leave should follow, but I can't put it further than that.
Yes, well, the reason I'm against you on it is not because this is not a serious matter, it plainly is, but on the face of it, the decision in next is authority in relation to the rules of court being a sufficient regulation for the purpose of establishing jurisdiction under Article 5A1E, and on the proper construction of Rule 2524, as with Rule 20.7, there is very little room for its operation if jurisdiction is not conferred by that rule.
But on that point, obviously, if a DIFC entity has proceedings in London, obviously a worldwide freezing injunction could be made against it.
No, I understand all of that.
So there is, yes.
That's back to the point as to whether or not you need another gateway. And,
yes.
And it seems to me that because next is authority for the basic proposition that rules of court can constitute regulations within 5A1E. The only question that arose here really was in relation to the proper construction of Rule 2524, and I can't see how that rule could operate if it wasn't in fact conferring jurisdiction.
But obviously,
all about.
A DIFC entity could have proceedings in London, and then an injunction could be sought in respect of those proceedings in London in the DIFC. So that's, I suppose, how Part 25, 24 is operating.
It would have a very limited operation, wouldn't it? Because in those circumstances, there would be substantive jurisdiction in the DIFC, but somewhere else might be a more convenient forum. That's really what it comes to, isn't it? That's, I think, the only scope for the rule to operate if it doesn't operate in the circumstances that I've mentioned. So I'm afraid you'll have to go to the Court of Appeal and seek permission to appeal. And so no question of any stay pending appeal arises. And I'm not giving you a stay pending the application of your permission to appeal in the Court of Appeal either. So you can assume that whatever order is made will be an immediate order, whether it be for reference to the Attorney General or in terms of fine. Cost, do you want to try and deal with costs now? I mean, I think costs must follow the event, mustn't they, Mr. Pacifica? Can you say anything about that?
All I can say would be an application for a stay, but the court has already indicated its position.
Yeah, well, you're already owing 250,000 in costs. I'm not going to stay that. Am I being asked to assess the cost, Mr. Ball?
I'll just take instructions on that if my solicitors could just let me know.
I know that schedules have been provided, but I haven't looked at them in any detail.
Yes, I am being asked if the court would be minded to assess them. That would be grateful.
My application would be for a detailed assessment.
Well, let's look at the figures first, shall we, and then decide what may or may not be appropriate.
There's 3 cost schedules at Bundle R.
Ah, yes. Hold on. Oh, they're in Bundle R, are they? Okay.
Yes.
All right. Well, which one do you want me to look at first?
Should we go? Well, let's look at the contempt one application first. That's one I have it open.
Yeah.
We'd simply say there's a lot of work that goes into this. The contempt isn't something that lawyers come across very often for obvious reasons, and therefore research and the like has to go into. It all has to be done well. And this figure we would say is reasonable in the circumstances. We're dealing with a large claim.
This is a dollar figure, is it?
I believe so.
Yes, it is. $500,000. No.
What I can't see is the defendant's cost. I don't.
Well, the defendants have submitted some costs because I got an email, but I haven't explored that.
It may be worth looking at those. I can't see them on my computer right now.
I think they have not been added to the bundle, but they were submitted.
I believe they were submitted late, but do we know the amount of those costs?
I can get the amount. The amount is in dirham. It's approximately 1.3 million. I can get the precise figure, dirham, not dollar. So roughly speaking.
Did you say 1.6?
I'm just getting it up on screen now.
Yeah, no, I think it's 1 point. I think it's 1 point. I'll just find the figure. It is.
$1.386 million dirhams.
So that's 377,000. So I don't think we would submit there's not an extreme discrepancy between the two, which is another indication that those costs are about right for these particular proceedings.
My understanding that the figure claimed for those 3 applications from the defendants comes to adding together approximately $600,000. Is that correct? I've just added them together now. Whereas the claimant's figure would be 377.
Well, I just put in what's 1.38 million is, but
your figure, Mr. For the defendants is respect of everything, is it?
Yes.
Yes, it says in respect of applications.
I think it also doesn't include
contempt application and
November.
That doesn't reflect any costs after the 1st November. Right. So there'd be a bit to add on anyway.
There's a huge amount of outlay, I think, in the claimant's bill of costs, and it's not simply counsel, but it's a whole series of third parties. And in those circumstances, I would seek a detailed assessment, just given the huge amount of outlay.
Well, there's asset tracing investigators' fees, isn't there?
Yes, and there's a good question as to what this is.
1.218 million. Oh, hold on, no, what's that? Yes. I'm looking at the expenses disbursements. GPW, is that 1.218 million? Looks like it. Oh, no, it isn't. That's item 4. That's $1,218.35, isn't it?
Yes.
Right. Then Holland and Knight have $121,000. And Mr. Board is shortchanged by comparison.
Yes, I am. I'm very cheap. What I'm being told about that is these investigators, of course, are necessary because the defendants were in breach, and therefore.
I understand that.
Yes,
I understand that. I was just looking. I'd misread the amount, but it's about 50,000.
There is a general principle, I think, the court would be aware of, that the costs of making your case usually are not recoverable. As a general principle of law. Now, in those circumstances, I would seek a detailed assessment, just because there are certain questions about those, whether that is recoverable.
Well, I'd say that's highly disproportionate in this case, and in fact, we haven't discussed the basis for these costs, which we'd say should be on an indemnity basis, given the lack of engagement, even at this very late stage in the submissions that are being made.
Right. Well, let's have a look at the other 2 figures as well. Let me just see those, Mr. Bohr.
Yes, the unless order, I think, as you expect, much lower.
The unless order is
30,000. Yes. And then the other figure is 78,919.
Yeah. Right. Okay. Well, I think the right thing to do is to make an order for interim payment and refer the rest for assessment.
On that, my lord, I'm going to try and resist that just because of the difficulty of engaging with these defendants and the difficulty that the claimants have been put through already. I mean, this is going to create more costs which may not be paid, and can kick things into the long grass.
Well, that I understand, but if there's going to be any purging of contempt, this will be an additional matter that will have to be taken into account and prima facie paid, isn't it? I mean, of course, it's possible the defendants may decide they don't want to wish to purge their contempt and don't wish to do anything, but that's a matter for them.
Yes, although there's a matter of timing. In other words, if the court made a decision as to a cost amount now, then when it comes to sentencing, or at least the penalty being implemented, the court would have a good idea whether or not there's going to be compliance. If in fact the detailed assessment is going to be a longer process, then the court won't have the benefit of knowing whether the costs have been paid or not.
Appreciate that, but if I'm going to make an interim payment, there's going to be some due straight away anyway.
Yeah.
So it's just a question of what really makes the most sense in the context of what is. Perhaps I should ask the defendants which parts of this major bill they take exception to.
Well, this was only received by our side yesterday, so I haven't had a full opportunity to review it. I didn't expect to have to make submissions on it today, but I think the major issue, I think, would be number one with respect to the outlay. But I would appreciate an opportunity to fully look at it, because I think there's a question not with respect to the outlay. I think it's not simply that this quantum is too high; it's that whether or not this is even recoverable. These heads.
So which parts are you referring to? I mean,
well, I guess investigations. So asset tracing investigations.
But overall, they're not huge figures, are they? Once you read them right, I thought for a minute it was 1.218 million, but it's 46,000 plus 1,218, and then there's the American lawyers' fees.
Again, it's unclear as to how that is part of the proceeding.
I take that point about Holland and Knight.
So I did not come to court today prepared to make submissions in respect of these statements of costs.
Probably should have done.
Well, my submission would be we should have a detailed assessment.
Right. Well,
and the costs, I mean, just judging by the two sets of costs, I mean, my rough calculation is that the claimants are seeking something like, I think it is 600,000 in total, and that's on top of the 250,000 they've already sought. So their total costs to date would be something like 850,000, whereas our total costs are roughly speaking 370,000. So it seems to be more than double. That would be my main observation. And again, given the complexity of these matters, I would submit that a detailed assessment would be the way to proceed.
Well, I'm going to order an interim payment of $400,000 and assess the rest to go to assessment. I'm confident that there would be recovery of $400,000, not least because the defendant's own figures are of that order. So when I talk about 400,000, I'm referring to all three applications in total, an interim payment in respect of all three, and the rest to be the subject, the whole bill to be the subject of detailed assessment by the registrar. And if there's no cooperation from the defendant, then you just go to the registrar and get the registrar to assess. Very simple.
Yes.
All right. So that's costs.
And of course, there's still the 250,000 as well outstanding.
Yes. And
yeah.
I mean, on the face of it, as I say, one would have expected any purgation to include payment of all sums that have been ordered by the court.
Yes.
But that's a question for another day.
Yes.
So shall we? There's nothing else we can usefully do today.
No.
I apologise. There's been quite a lot of toing and froing, but I think it's been helpful. And we'll come back at 9 o'clock London time. Sorry, 8 o'clock.
Yes.
8 o'clock London time tomorrow, 12 o'clock Dubai time, with a view to determining whatever has to be determined in the course of an hour, so that my next matter is not held up.
Yes.
But there shouldn't be more than an hour's worth of.
No. I'm grateful. Thank you very
debate.
much.
Thank you very much, Judge.
Thank you.
All right. The only thing I might just add is this, Mr. Pasifka, that if you have any instructions of any kind, whether in the context of purging the contempt or anything else, it might be sensible to advance those in writing by email or whatever to the court or to Mr. Board or whatever. Self-evident you may not, and that's simply part of life, so as they say.
My understanding is, just to correct me if I'm wrong, but no formal order is made as of now. The formal order will be drawn up tomorrow. Is that correct, just in terms of timing? The formal order is yet to be made? It's
in relation to what?
In relation, I think, to all applications. There may be just some submissions on the wording of the final order, just in terms of what has been decided. For example, just has our set-aside application been dismissed in its entirety, or has it partially? There are those issues I'd like to resolve.
No, it's well, just to make it plain, it's been dismissed in its entirety. The form of words would have to state that the court had heard the defendant's application, had made a ruling that it was prepared to hear the arguments as to jurisdiction as set out in attachment A, that there was a finding that the defendants were in contempt of court in failing to obey the orders of the court requiring disclosure and payment of costs, and that the court had not been prepared to listen to hear argument from the defendant in relation to the other matters outside attachment A. So essentially it would recite the effect of the rulings that I've made, as well as dismissing the application.
Yes.
The formal order in relation to the contempt itself will follow tomorrow.
Yes.
When I've decided what the appropriate course of action is to take in the light of your submissions tomorrow.
And thank you very much.
Is that relatively clear?
Yes, I think we might try to circulate a draft order for.
Good idea. Good idea. We could then, if we can actually agree that tomorrow, that would make sense.
Yes.
But if you could circulate it between you and discuss it and see if you can agree it, so much the better.
Yes.
I'm sure. Yes, Mr. Moore, you want to say something?
There was one other point, and that is the basis for the cost assessment. Will that be indemnity costs?
Yeah, it will be indemnity costs, yes.
Yeah. I'm grateful. Thank you.
All right. Very good. 9 o'clock, 1 o'clock tomorrow, please. Thank you very much. If you'd just like to sign out, then I can have a quick word with the associates. Thank you very much.
Sorry, I think it's 8 a.m., 12 a.m.
I'm so sorry. I keep thinking it's only 3 hours, but it's 4 hours at this time of the year.
Thank you very much.
I wish it was 9 o'clock rather than 8 from a London point of view, but
Thank
that's life. All right.
Thank you.
Thank you very much. Thank
Bye.
you.